So good morning, good afternoon for all the attendees in the 19th International Law Winter Program of Brazilian International Law Center, CEGIM. My name is Thiago Almeida, a PhD student at the Federal University of Minas Gerais and a researcher at the University of Geneva. On behalf of the International Law Center, I welcome all you to the lecture of the most esteemed Professor Pierre d'Argens. Professor Pierre d'Argens is a full professor at the University of Louvain, member of the Institute of International Law, and member of the Brussels Bar Special Course of Foley and Special Counsel of the Foley Hague LLP. He served as the first secretary of the International Court of Justice, author of the award-winning book, A Published Course of the Hague Academy, and over 100 articles and book chapters. He is also a member of editorial boards of the Annuaire Français de Droit International, the Revue Belge de Droit International, and the European Journal of International Law. He's currently president of the European Society of International Law. As counsel and advocate, he has acted 11 cases before the International Court of Justice and in 6 interstate arbitrations, as well as an investment arbitration and a human rights case before the European Court of Human Rights and African Commission on Human and People Rights. He also represents international organizations before national courts and arbitration proceedings. The topic today will be nullity of interstate arbitral awards. There are many viewers today with us, Professor, and once again, I want to thank you for your availability to be here with us at CEGIM, and the floor is yours, Professor. Thank you again to be with us today.
Thank you very much, Thiago, for this generous introduction. I'm very pleased, ladies and gentlemen, everyone, very pleased to be with you on Zoom this morning for you. It's a pleasure. It's the second time I'm hosted by CEGIM, and I'm very grateful for the opportunity to give this lecture. As indicated by Thiago, the lecture will be about the annulment of interstate arbitral awards. Now, we all know as lawyers that there are other type of arbitral awards. There are commercial awards in domestic settings. There are investment awards in relation to investor-state disputes. And then there are also interstate arbitration awards, arbitrations awards that are rendered in disputes between 2 states. And those are about the validity of those arbitral awards that I would like to talk today. A few words, however, on the nullity, the validity of commercial awards and of investment awards very quickly. Arbitration is an old thing in every domestic legal system. And it is an exercise of private justice. It is not the state courts that are used to settle the dispute, but the dispute between private actors, between merchants and traders and commercial arbitration. The dispute is settled by private individuals. They are not paid as judges by the state. They are paid by the parties. And their activity to render justice takes place on the territory of a specific state. They don't deliver justice at sea. Arbitrators are sitting somewhere. And in commercial arbitration, in every country in the world, you have provisions under the national rules concerning the procedure, the judiciary. You have the legislature of the state that accepts that on the territory of the state, some form of private justice is delivered. And that private justice will be enforced in the domestic courts of the state. But this right to deliver private justice is always, and to a different extent, from jurisdiction to jurisdiction, this right to deliver private justice is always supervised by the state. In other words, you will find in legislations around the world, you will find laws that govern the validity of arbitral awards that have been rendered on the territory of the state. So the seat of the arbitral tribunal is of a paramount importance, because where the tribunal meets, where the tribunal has its seat, will indicate what is the law applicable to the validity of the arbitral award. And you will find in a very common way, you will find in the laws of the states concerned, in the law of the seat state, you will find the grounds for nullity of arbitral awards, and also the procedure by which you can go to the local courts and ask the local court to annul the arbitral award. And the reason for that is because there is this right to deliver private justice, but this right is not uncontrolled. The state says that the arbitrators must at least behave in certain way for their judgment, for their award to be valid within the legal system of the seat where the arbitration took place. So that is pretty common, and you will find that everywhere. I mean, the sovereign state does not deliver justice itself through its own courts. It allows private courts to do that, private arbitrators to do that, but on certain conditions. So that right to deliver private justice is supervised by the state, because it is a fundamental function of the state to deliver justice. And if it is not the state itself delivering justice, but arbitrators, the state nevertheless gives reassurance to private parties that this private justice on its own territory will not be done in bizarre ways. There will be limits to what the arbitrators can do. And you will find that, as I said, in many countries around the world. And countries around the world will legislate about that. And you have famous centers for arbitration. And those centers for arbitration, for instance, in Paris, the ICC, International Chamber for Commerce in Paris, or the Stockholm Arbitration Center, or the London Arbitration Center. The reason why those centers are successful is because the domestic laws of the state in which they are situated are very limited in terms of the grounds that can be used to claim before local courts that an arbitration award is null or void. In order to develop the legal industry of arbitration, if you want, because it is an industry, let's face it. I mean, there are a lot of cases that never go before domestic courts and that are solely litigated before arbitral tribunals. And that's a huge economic activity, not only for the arbitrators, but for the lawyers involved on both sides. If you want to develop that legal industry, you have a local law which is fairly generous, which gives a lot of autonomy to the arbitral proceedings and to the outcome, and protects the outcome, tries to limit the grounds under which you can contest the validity of the arbitral award. And the more restricted those grounds are, the more, if you want, the more valuable the seat for arbitration is, because the award will be final and binding, and the possibility to attack the validity of the arbitral award will be very limited. Will exist, but will be very limited. Okay, so that it is very important. And commercial arbitration is used, I mean, all around. I mean, it's a huge part of the world economy. There is not a big contract to build bridges abroad, or to construct rail tracks, or to expand a harbor, or to build new tourist resources, there is not a single important commercial contract that does not include an arbitration clause. Why? Well, because sometimes the local courts where you have your commercial activity are not very much reliable for all sorts of political reasons. There might be bribery, there might be corruption, there might of local courts, there might be political influence of the state in local courts, etc. And that is why you have arbitration, commercial arbitration. So you escape from the local courts, and in the contract, which is governed by a specific rule, specific law that the parties choose, in the contract you include a procedure for settling disputes in relation to the contract through arbitration. And you will go and pick and choose a seat of arbitration which is protective of the arbitral procedure. Okay, but you will always find, even if you are in a country which is protective and generous with arbitration, you will always have rules on the nullity of arbitral awards. Likewise, in investment awards, and in particular, in the context of the ICSID Convention, the Convention for the Settlement of Investment Disputes, the Washington Convention of '65, you will find in Article 52 also grounds for nullity of investment arbitral awards that have been rendered on the basis of the ICSID Convention, and the procedure that is described there is a procedure fixing the grounds for nullity, the reasons why you can impugn the validity of an arbitral award, of an ICSID investment award, and also the specificity of the ICSID Convention is to give power not to local courts, but to deprive local courts of their power to annul an investment award, and to give that power of annulment to an ad hoc committee that sits, if you wish, as the judge of the validity of the ICSID investment award. And that is very, very important also. But I'm not going to talk about ICSID annulment, and I'm not going to talk about commercial award annulment. I'm going to talk about the interstate arbitral awards and the grounds and the procedure by which those interstate awards could be contested in terms of validity. Now, the basic point of departure is that states may submit by agreement their disputes to arbitration. And you know that there is no compulsory jurisdiction in international law, but interstate arbitration is a long-standing feature of international law, and international arbitration is a pacific means for the settlement of international disputes. And states may conclude treaties by which they decide jointly to submit their dispute to an arbitral tribunal. They can write a special treaty, a compromis, that gives jurisdiction to an arbitral tribunal to settle a specific dispute. You will also find in treaties, in multilateral treaties, you will find compromissory clauses that indicate that if a dispute relating to the interpretation or application of that treaty is not settled by negotiations, then that dispute can be settled by arbitration. Or if there's a failure to agree on an arbitration, that the dispute will go to the International Court of Justice. Okay, so you have various forms of compromissory clauses, and you have also the possibility to conclude a special agreement giving jurisdiction to an arbitral tribunal. And in all cases, the arbitration ends with an award which is binding on the parties and final. the specificity of interstate justice is that the award is final and binding. Very rarely, and I've never seen a case where the procedure is set out in such a way that the arbitral award would not be said to be binding, or that the arbitral award would be open to appeal. There's usually no appeal in interstate arbitration. It's a one single proceedings without appeal. The only possibility, therefore, to contest the outcome, that is the award, is not to say that the award needs to be appealed and decided again, is to say that there are grounds for that legal act, which is the award, not to be binding, that the validity of that specific legal act is not binding because the award is a nullity, null and void, and therefore deprived of its binding effect. That is the issue of invalidity. Okay, so the nullity, the proceeding contesting the validity of an award means contesting the fact that the award is a legal act producing its legal effect, and that from its inception, the arbitral award is null and void. It's not to say that it was badly decided. It's not to say that it needs to be appealed and revised. It's simply to say that there is something wrong with that legal act, and that legal act actually is not binding because it is null and void. Ab initio, okay? Nullity is always ab initio. And that is what I would like to try to cover and to try to understand in the context of interstate arbitration. Now, let me immediately say that in contrast to what exists in commercial law or in commercial arbitration or in investment arbitration, there are no universally accepted grounds to contest the validity of interstate arbitral awards, and there is no specific procedure to contest the validity of interstate arbitral awards. Now, and I will come to the procedure, but of course, if there is an arbitral award that has been delivered, the presumption is that this award is final and binding, must be respected. If one of the parties to the case, and most likely the party who lost the arbitral proceedings, if that party begins to contest the validity of the award, that party needs to bring forward some grounds for contesting the validity. And the question is, which are the grounds that are acceptable under customary international law, because there is, or under the general principles of law within the meaning of Article 38 of the statute of the ICJ, because there is no general treaty listing the grounds for nullity. And the second question is, well, if there is a contestation about the validity of an arbitral award, that contestation gives rise to a new dispute, a dispute about the validity of the award, and that new dispute needs to be settled by peaceful means, because the general rule under international law is that disputes between states must be settled by peaceful means, or at least that if there is a settlement, the settlement must be a peaceful settlement. But there is no general, and you see there is a new dispute. There was a previous dispute that was supposedly settled by the arbitral tribunal in the award, but now that award, the validity of that award is contested. And that gives rise to a new dispute, and that new disputes need to be settled. And the question is, before which judge, on the basis of which grounds, on what basis can you claim the nullity of an arbitral interstate award? Now, let me go through those two questions, and let me illustrate also by referring to only two cases so far. There have been, I said, there are no general rules. There's no general treaty providing and being enforced, providing for grounds of nullity. Although there have been two attempts. A very old one in 1875, the Institut de Droit International, which was created just 2 years before, in 1873. In 1875, the Institut de Droit International adopted a set of draft regulations for international arbitral procedure. And there's it's a full set of arbitral rules, if you wish, encouraging states to go to arbitration and presenting to states some rules of procedure in order to facilitate so that state can opt in and use those rules that are set there already for states to use. And this is one of the first set of arbitration rules. After that, we have the rules set out in the Hague Convention of 1899. But prior to the Hague Convention of 1899, we have the Institut Droit International draft arbitral regulations. In that draft, the Institute included an Article 27, which in French, and the Institute was working in French at the time, in French, Article 27 of the 1875 regulation states, la sentence arbitrale est nulle en cas de compromis nul ou d'excès de pouvoir ou de corruption prouvée d'un des arbitres ou d'erreur essentielle, full stop. Which means in English, the arbitral award is null for 4 possible reasons, 4 possible grounds. The compromis, so the special agreement by which the arbitral tribunal was established, is itself a nullity. The basis of the power of the arbitral tribunal is a nullity. Or the tribunal exceeded its power, excess of power, or there is corruption, established, proven corruption on the part of one or several arbitrators, or an essential error has been committed by the tribunal. And that's it. And in 1875, those are the four grounds set out by the tribunal, by the Institute, sorry. There is no procedure for claiming nullity. As I said, if there's a claim of nullity on the basis of one of those grounds, there would be a new dispute in need of eventually being arbitrated. The question is, those 4 grounds in 1875, were those 4 grounds reflecting already customary international law at the time or not? Or were they simply proposed by the Institute as a way to develop international law? And we have no clear answer to that. Okay, it's clearly the first time that any rule about the nullity of interstate arbitral award is put on paper. But the Institute is a private body. It's not a state entity. It's a learned society of private individuals who are elected among their peers because they supposedly know international law. But there you have 4 grounds. What is very interesting, I mentioned the Hague Convention of 1899 and of 1907, and there are also rules on arbitration in those set of rules. But there's nothing about the nullity of arbitral award. It is simply said that arbitral awards are final and binding, and there are no rules, no grounds for nullity that are set out in those Hague regulations. And we have to wait until 1958 to have another set of rules by another body that is in charge of codifying international law, a body which is now an official body of the UN, the International Law Commission. And in 1958, the ILC adopted the famous model rules for arbitral procedure. And in those model rules of 1958, there are some provisions included about the nullity of arbitral awards, and those rules apply to interstate awards. Again, this is not binding as such. This is a set of rules that parties to a dispute need to opt in. They must specifically agree on those rules. But the same question arises. This is the International Law Commission, supposedly codifying existing international law and developing international law. And so the question is, are those grounds for nullity, do they reflect customary international law as customary international law existed in 1958? Or do they develop, are they there for the progressive development of international law? Now, if we turn to the validity and annulment of arbitral awards under the 1958 model rules of the ILC, we find Article 35, which sets out 4 grounds again, but slightly different. Some of them overlap with the Institut grounds, and some of them do not. The validity of an arbitral award may be challenged by either party on one or more of the following grounds. A, the tribunal has exceeded its powers. That is similar to what excess of power was also in the 1875 Institute resolution. B, that there was corruption on the part of a member of the tribunal. That also was envisaged by the Institute in 1875. And that C, third ground, that there has been a failure to state the reasons for the award or a serious departure from a fundamental rule of procedure. That is new. That is not included in the Institute resolution of 1875. And then D, that the undertaking to arbitrate or the compromis is a nullity. And that already existed in 1875 in the Institute resolution. Okay. So there you go. In 1875, there was this idea of essential error that you do not find in 1958. But what you do find in 1958 and did not exist in 1875 was the idea of the failure to state the reasons or a serious departure from a fundamental rule of procedure. Okay, so and then the model rules of the ILC continue in Article 36 and 37 to set out a procedure for annulment. Where the case, the new dispute would be settled by the International Court of Justice. And what is also interesting, the Article 36 says within 3 months of raising the nullity claim, if the dispute is not settled, or if the parties have not agreed on another arbitral tribunal, the dispute can go to the ICJ. But that, of course, requires the consent of the parties to be submitted to the model rules of the ILC. And what is very interesting also is that paragraph 2 of Article 36 sets out certain time limits for contesting the validity of awards. That's pretty interesting, which gives the idea that you need legal certainty. Yes, you can contest the validity of arbitral award, but there are certain temporal limits to that claim of nullity. And again, here the ILC is proposing rules. Okay, we don't know this. There's very little practice, as I shall recall. So it's extremely difficult to assess whether this is exactly a reflection of customary international law or a reflection of general principles of law. What is true in domestic settings is that usually you also have time limits for contesting the validity of arbitral awards, because legal certainty is a protected value in any legal system. And in the ILC draft, for instance, the ILC says you can only contest the validity of an award during 6 months if the ground of validity, six months from the rendering of the award, when the ground of nullity is excess of power or failure to state reasons, or that the procedure was improper. And then it is 6 months from the discovery of the corruption, or from the discovery of the fact that gives rise to the nullity of the compromis, of the special agreement by which the arbitral tribunal was established. And in any case, says paragraph 2 of Article 36, you cannot contest the validity of an arbitral award after 10 years of the rendering of the award. So this idea that there is a limited amount of years during which legal uncertainty can exist. And if you look at the ICJ statute in terms of revision of the judgments of the court, you know that judgments of the ICJ are also final and binding and are not susceptible of being appealed, and that there are only 2 ways, 2 grounds, if you wish, by which you can ask the ICJ to revisit a previous judgment. It is either through a request for interpretation of the judgment under Article the revision is Article 61, and the judgment on no, my mind is I'm losing my mind on the specific provision of the statute concerning the dispute concerning the request for interpretation of the judgment of the court. It's Article 60 of the statute of the court. The judgment is final, but if there's an event, a dispute concerning the meaning or the scope of the judgment, then the court can entertain a request for interpretation. That request for interpretation, there is no time limit for the request for interpretation, but there is also a 10-year time limit for the request under Article 61 for the request for revision. After 10 years, this request for revision is inadmissible. So you have the same idea of the finality of the legal decision, of the judicial decision. Now, so those are the grounds that we can find either in the Institut resolution of 1875 or the 1958 ILC rules, model rules on arbitration. And as you can see, there is some overlap, which probably supports the idea that, well, those grounds are solid grounds, and they are quite common sense grounds. If there is corruption of the arbitrator, of course, if there is corruption, then but corruption needs to be established. Of course, you need to prove it. Is the burden of proof is on the shoulders of the party who claims that there has been corruption, and that the corruption was instrumental in the outcome. If the compromis, if the arbitral agreement itself is a nullity, then, like a treaty can be null and void, then of course there is no basis for the power to adjudicate, and there is no ground for having a binding arbitral award. That's quite common sense. And likewise, if the tribunal has gone beyond what it was asked, excess of power, that's quite common sense also. The tribunal, the arbitral tribunal, has a specific mission. If the tribunal goes beyond that mission, if the tribunal decides on a certain matter that it was not asked to decide upon, then it did something it was not authorized to do under the compromis, under the special agreement, and then the award is null. That is pretty common sense, and that is probably quite unquestionable. As far as the other grounds are concerned, the essential error, what does that mean under the 1875? Is that a ground for appeal? What is the difference between making an error of judgment and revisiting the judgment itself? And is that an acceptable ground of nullity? And likewise, the failure to state reasons or the serious departure from fundamental rule of procedures. One can understand, I mean, the equality of parties is so important that if the arbitral tribunal does not behave as to afford equality between the two parties, same amount of time to plead, same amount of months to file briefs, then that would be pretty inappropriate and probably a very strong ground for nullity. But this is very, very unlikely to happen. The interstate arbitral tribunal will always be extremely careful to treat parties equally. And it must not be a simple rule of procedure that has been departed from, but it must be a fundamental rule of procedure. And those fundamental rule of procedures are fairly limited, and basically they amount to equality of parties and to the prohibition of contacts between parties and arbitrators outside the realm of the proceedings itself. And then the question of the failure to state reasons. That is pretty understandable as a ground for nullity today. But if you look at the history of international law in the past, in particular in the 19th century, it was quite common. And that is why the Institute does not speak about it. It was quite common at the time that arbitral awards were fairly shortly reasoned. Okay. And it is a question. And it's a question that needs to be, of course, looked from a temporal perspective. Maybe today the failure to state reasons is a ground for nullity, but has it always been the case in the past? And that is an open question, and I'm not going to enter into that question. Let me turn now, and again, on the procedure, let me just recall that there is no specific procedure for annulment. So it creates a new dispute, and that new dispute needs to be adjudicated. It's a fundamental legal question. It's not really an issue that can be, negotiated. And of course, an agreement between two states saying that we agree that the arbitral award is null and void, that doesn't mean, it is possible. They disregard, they jointly agree not to be bound by the arbitral award, but that is not really an agreement about the nullity of an arbitral award. And there's no example of agreement about the nullity of an arbitral award. You will always find one party disagreeing that the award is a nullity because the other party has an interest in contesting the validity of the award because the outcome of the award is not of its liking. So you will not find such agreement about the nullity of an award. What you will find is a claim for nullity, creating a new dispute, and then eventually an agreement to put that new dispute so far to the ICJ. We don't have arbitral awards about the nullity of previous arbitral awards. What we have is ICJ cases about the nullity of arbitral awards. And so far we have 3 cases. One is not yet decided, which is, and as you are, most of you in Latin America, you certainly are aware of the dispute between Guyana and Venezuela. about the validity of the 1899 arbitral award of Paris that was delivered at the time, following the Treaty of Washington concluded in 1897 between Great Britain at the time and Venezuela. And you know, it's a very long dispute between the two countries that arose when Guyana was about to become an independent state. The arbitral award was implemented on the ground. Delimitation was established. There's a tri-point with Brazil in the forest between the three states, the neighboring states, and it was demarcated on the ground in 1905. And then it was only later in the 60s that the arbitral award began to be contested by Venezuela. And there was a huge, and there is still a big dispute between the states on that, on the validity of the award. As I'm counsel to Guyana, I'm not going to say with my colleagues, I'm not going to say anything about that dispute. It is pending. And Guyana says that the arbitral award is perfectly valid. That the court has jurisdiction to decide on the matter, which the court agreed with, and the case is pending on the merits, and Venezuela is contesting the validity of the arbitral award, has been doing so diplomatically for many decades and continues to do so before the ICJ. And Venezuela was of the view that the court had no power to decide had no competence, no jurisdiction to decide on the validity of the arbitral award. So I'm not going to say more about that case. The two other cases that we have in the ICJ is a case between Honduras and Nicaragua, decided by a judgment of 1960, the arbitral award made by the King of Spain. And then the second case is a case concerning Guinea-Bissau and Senegal, an arbitral award of 1989, which was decided by the court also. In both cases, the court upheld the validity of the arbitral award. Okay, so so far we have no case in which an interstate arbitral award has been quashed, declared null and void by the ICJ. Now, let me go quickly in those two cases, if I have time. You can read, of course, about those cases and the judgment of the court are available online. Now, the arbitral award made by the King of Spain was the result of a treaty of 1884 between Honduras and Nicaragua. In that treaty, the two states agreed to submit to arbitration the delimitation of parts of their boundary, the part of the boundaries that their respective mixed commission for delimitation could not agree upon. So they had the mechanism between the two to try to set up the border, and if that mechanism did not result in an agreement, there was an agreement to arbitrate the parts of the border that were contentious, that were not where parties did not find agreement. And the King of Spain rendered an arbitral award on that basis in 1906, delimiting the part of the border that was not delimited by agreement between the parties. In 1912, so 6 years after the arbitral award, Nicaragua began challenging the validity of the binding character of the award, the validity of the award. And that created a dispute that lasted for more than 40 years, because it was in 1957 that the two states, by a special agreement, submitted their disagreement about the validity of the 1906 award to the International Court of Justice. And it is Honduras, which is the state, Honduras considered that the arbitral award was valid. It is Honduras that came to the ICJ to ask the court to confirm the validity of the arbitral award. It is not Nicaragua, which was the claimant in that case, but it was Honduras. In a very similar way, in the Guyana-Venezuela case, the respondent in those cases is the state contesting the validity of the award, which is interesting. Not problematic as such, but interesting. In that case, Nicaragua raised several grounds for nullity. The first reason allegedly by Nicaragua was the fact that the arbitrator was not designated in conformity with the Treaty of 1884, and that the King of Spain was not established duly under that agreement. The court decided that was wrong, that the procedure had been duly followed for the designation of the arbitrator. And the court also interestingly stated, in terms of burden of proof, that it was up for the party contesting the validity of an arbitral award to prove the ground that it raises. Okay, the burden of proof for annulment rests on the party seeking annulment. That's, of course, very important. There is, in other words, a presumption of validity because the arbitral award is final and binding per se, and it can only be challenged on certain limited grounds, and it is for the challenger to prove the invalidity. It is not for the state which considers that the award is valid to prove the validity. It is for the contesting state to prove the invalidity. That is pretty important. Then Nicaragua also said that the treaty, the compromise of 1884, had lapsed before the designation of the King of Spain in 1906. And then the court said this is a wrong argument because Nicaragua was saying that the treaty of 1884 entered into force by the signature. And Honduras said, no, it's not the signature that triggered the entry into force of the treaty, and the treaty had a limited validity of 10 years. But the court agreed with Honduras to say that the treaty became binding, and therefore the 10-year period began to run from the moment of the ratification of the 1884 treaty, not from the moment of the signature. So the court agreed with Honduras' interpretation, and therefore the court found that the King of Spain was designated as an arbitrator during the time of the binding effect of the 1884 compromise. Then Nicaragua, in the alternative, also argued that it used the Institute and the ILC draft articles. Excess of jurisdiction, essential error, lack or inadequacy of reasons in support of the findings. And the court said that by its express behavior, and you remember it's a very short period of 6 years, but during those 6 years, Nicaragua did not contest the validity of the arbitral award. And so the court said Nicaragua acquiesced to the validity of the arbitral award. And Nicaragua, by express declaration and by conduct, recognized the award as valid. And the court says it is therefore no longer open to Nicaragua to go back upon that recognition and to challenge the validity of the award. So this is an argument based on acquiescence. And it reflects this idea that there's a limited amount of time that exists for contesting the validity. If you complied with the arbitral award, then acquiescence can be derived from your compliance. But the court went further and said, even in the absence of Nicaragua's acquiescence, the award would still be valid because none of the grounds of nullity alleged by Nicaragua were present. And the court also made clear that its duty was not to act as a court of appeals over the arbitral award. The court is not called upon to pronounce on whether the arbitrator's decision was right or wrong, said the court. These and cognate considerations have no relevance to the function of the court that the court is called upon to discharge in these proceedings, which is to decide whether the award is proved to be a nullity having no effect or not. And the court therefore decided that Nicaragua was under an obligation to give effect to the arbitral award, which was binding from the moment it was issued and validly issued by the King of Spain. Then the second case, which is closer in time, is the case between Guinea-Bissau and Senegal about the arbitral award of 31 July 1989. And this was an arbitral award that was the result of an agreement between the two states concluded in 1985. And there were two questions put to the arbitral tribunal to decide. There was an agreement concluded by exchange of letters in 1960 between the two states relating to the maritime boundary, and the arbitral tribunal was asked to decide whether that agreement had the force of law in the relations between Guinea-Bissau and Senegal. And the second question was, in the event of a negative answer, if the arbitral tribunal were to find that there was no binding agreement concluded in 1960 over the maritime boundary, then in the event of a negative answer to the first question, the tribunal was asked to decide on the course of the line delimiting the maritime territories of the two parties. And by a decision of a 2-to-1 majority arbitral award, the tribunal in 1989 gave its decision, delivered its award, and it held that the 1960 agreement that was the result of the exchange of letters between the parties was a binding agreement between them. And therefore, it was valid, and that there was therefore no need to answer the second question. Because remember, it was only if the answer to the first question is in the negative that the tribunal had to decide on the second question. But the tribunal said that the 1960 agreement only governed the maritime delimitation about maritime spaces as they existed at the time. That is the territorial sea, the contiguous zone, and the continental shelf. The tribunal said that the 1960 agreement did not delimit and govern the exclusive economic zone, which at the time was a notion that did not exist in international law as such in 1960. And therefore, the tribunal said, I don't need to answer the second question, but the president of the tribunal appended an opinion to the decision saying that because that the tribunal could have actually answered the second question as it relates to exclusive economic zone. The tribunal, the president of the tribunal said that, was of the opinion that the tribunal could have exercised its power under the second question because part of the maritime delimitation was not decided by agreement in 1960. And the dissenting arbitrator, in his opinion, said that the arbitral award was incomplete and inconsistent with the letter and the spirit of the arbitration agreement. And very quickly, just a few weeks after the arbitral award was rendered, Guinea-Bissau started contesting the validity of the arbitral award. And in order to do that, Guinea-Bissau came to the ICJ and used the optional clauses. You know the mechanisms of optional clauses under Article 36, paragraph 2 of the ICJ statute, which is this declaration by which a state can accept the jurisdiction of the court. Well, Guinea-Bissau and Senegal had made declarations pursuant to Article 36, paragraph 2. And so the court had jurisdiction to decide on disputes between them. There was a new dispute about the validity of the arbitral award, and the court had jurisdiction to entertain that dispute. And Senegal did not contest the jurisdiction of the court under the two optional clauses. So the court decided it had jurisdiction to decide on the claim of nullity and proceeded with looking at the merits of that claim of nullity. And here again, the court made very clear that it was not an appeals court. It was not sitting as a court of appeal, but only as a court of nullity about the validity of the arbitral award. The first ground that was raised by Guinea-Bissau was to say that the arbitral award is inexistent because it was not supported by a real majority. You have the president who filed a declaration, you have the dissenting arbitrator who filed also, and Guinea-Bissau was saying, well, this shows that there is no real majority to decide this case and that the case was not properly decided. The court rejected that ground. The court said it is very common in international tribunals that a judge may vote in favor of the outcome, even if it would have preferred a slightly different outcome. Okay, but that does not diminish the value of the supporting vote of the majority. There's a majority for the existence of the award, even if the president would probably have liked the arbitral award to be supplemented by an additional part. But the court said the validity of the vote remains unaffected by the expression of the president. Then Guinea-Bissau also argued that the award was null and void on the basis of excès de pouvoir, insufficient reasoning because the tribunal did not reply to the second question, and because the tribunal did not append a map, which was requested under Article 9 of the arbitral agreement. The court rejected that ground also. The court said that there was no excès de pouvoir and that it was possible to understand the reasoning of the tribunal by simply reading the arbitral award. What is interesting into excès de pouvoir here is that excess of power is that the court agreed somehow with Guinea-Bissau that excès de pouvoir could be the failure to exercise a power that you have, not simply the fact of exercising too far the power that you have, but excès de pouvoir could be negatively the fact of not exercising the power that you do have. And remember, the right to answer the second question. And so that is a broad understanding of excès de pouvoir. At the same time, it's a narrow understanding of excès de pouvoir because it's only a manifest breach of competence that can be a basis for nullity, said the court. And in terms of insufficient reasoning by the tribunal, the court rejected that ground, saying, as I just said, saying that the reasons why the tribunal decided not to answer the second question are set out, and it is possible to determine by reading the arbitral award the reason why it decided not to answer the second question. The statement of reasoning, said the court, while succinct, is clear and precise. And so there is a rejection again of the claim of nullity by the International Court of Justice. And there you have it, ladies and gentlemen. I've been speaking a lot. I'm sorry. And now I open the floor for questions. We have a field of international law in relation to the settlement of disputes, which is very underdeveloped. I mean, it's a good thing in the sense it shows that there are not many contestation of the validity of arbitral awards, because there have been many arbitral awards rendered and very few disputes at the end of the day. Usually arbitral awards are duly implemented, which they are supposed to be, but as you can see, there are some possibilities to contest their validity. And I say some possibilities because international law is still is not extremely clear on the grounds for nullity. What remains pretty clear, however, is that there is this kind of presumption, I think, of validity of an arbitral award, and that it is for the party seeking annulment or claiming that the arbitral award is a nullity to establish that it is the case and to prove that this is the case. Okay, so I will stop here and I will take your questions, thanking you very much for your kind attention into this pretty technical issue. I hope I've not been going too fast and that what I said was understandable. Thank you very much. And I wait for your questions.
It's amazing. Professor, thank you a lot. On behalf of International Law Center here, it's a pleasure to have you. And also for this specific topic of ICJ, it's amazing to have this opportunity to discuss nullity of interstate disputes. I will check if you have any questions here, because I have some questions to ask you, Professor, if I may.
Sure.
It's very interesting about the last two decisions of ICJ. If you begin for the last one about Guinea-Bissau versus Senegal, you said in the annulment discussion, the second questions, there's a negative answer for non-binding. So the ICJ said we cannot, you don't need to answer the second part of the
arbitral award. The arbitral award said that.
Yeah, but it is possible to answer that question about to delimitate maritime border in the annulment decision, or we need to create a new process or a new judgment. We cannot answer that in the annulment. It is possible or not, because it will be more than, because you cannot, you'll be more than the possibilities of the annulment decisions. So you need to analyze the award and see that if we access the power, if they have reasons or not. But it is possible in the annulment decision to decide about the maritime border.
Oh, no, that was no. The filing by Guinea-Bissau was a filing of nullity, and I've not checked the two optional clauses, but it might be possible. I don't remember, but your question is, had the court decided that the arbitral award was null and void, would the court have the power to delimit the maritime spaces between the two states? That's your question.
Yes. In that decision.
Yeah. Well, that is a power given to the arbitral tribunal under the compromis of 1984. And as I said, the tribunal decided not to exercise that power. Guinea-Bissau did not submit to the court a request for, in the alternative, I mean, if the court finds that there is no valid arbitral tribunal, Guinea-Bissau did not say, and please the court draw the line between the two countries. Let me check again the in that case application of Guinea-Bissau. If I remember well, Guinea-Bissau did not do that. And as your question probably comes from the pending case between Guyana and Venezuela, where the court said that under the Geneva Agreement, it not only had the power to look at the validity of the arbitral award, but also, and I will be extra careful here, but in the dispositif of the judgment of the judgment on jurisdiction, the judgment of December 2020, the court decided that it had jurisdiction, and I'm going to read that to be sure I'm not using the wrong words, and we need to be extra precise and careful here. But let me find it again here. There we go. Finds that it has jurisdiction to entertain the application filed by Guyana insofar as it concerns the validity of the arbitral award of 1899, and also finds that it and the related question of the definitive settlement of the land boundary dispute between the two countries. Okay, so it has jurisdiction to entertain the nullity claim and the related question of the definitive settlement of the land boundary.
I see.
And the court found that under the Geneva Agreement, by which it found it had jurisdiction, a complex agreement that you can read about in the judgment. Now, what does that mean concretely? I'm not going to speculate. And of course, the second part of the dispositif of the court, the related question, is something that would only apply in the event that the arbitral award is found to be null and void, because then there would be no related question. That is the only possibility for a related question of the definitive settlement, because the award, according to Guyana, is the definitive settlement of the land boundary dispute. And if the award is upheld if the validity of the award is upheld by the court, that's the end of it. There is no related question. In the Guinea-Bissau Senegal case, the question put to the court was solely the validity of the arbitral award. But there again, had the court found that the arbitral award was null and void, then you go back in time, as it were, and the question would have been again, was the 1960 exchange of letters binding or not? That question would have remained. It's not a court of appeal. The court is the nullity does not say that it was wrongly decided. It simply says that there's a reason for the legal act, which is the arbitral award, to be non-binding, and back to square one in a sense. And then eventually Guinea-Bissau could have come to the court and ask the court to delimit the maritime spaces between the two states. That would have been a possibility. And in the course of that procedure, maybe Senegal would have said, well, there is no dispute about maritime spaces because there is an agreement in 1960. And so that the court would have had to find again if the 1960 exchange of letter produced any agreement between the parties or not. But I don't know if I answer your question, but that's what I would say.
No, that's amazing. It's amazing, Professor. You answered that, and just to final comments here about the other decision, Honduras versus Nicaragua. You said Honduras asked the ICJ to confirm the validity of the award. So, and the decision was yes, it confirmed, it sustained the decision, but could be possible also all the consequence of if we go to the annulment process and the ICJ did not confirm or declare null and void the decision. So what the grounds for the Honduras to ask the validity of the decision? So why Honduras
Well,
came to
maybe I was a little bit unprecise. Actually, Honduras asked the court to declare that Nicaragua was under an obligation to give effect to the arbitral award.
okay, to give effect to
that. To give effect, which presumes the validity, of course, of the arbitral award.
Oh, that's okay. Okay, Professor, let me check here if
Are there any other questions?
Yes, we have a question here in the YouTube. Lucas Fontura said, I have studied in your university, professor, University of Louvain, the creation of a second degree arbitration body. So, Rari discussed with us the creation of a second degree of arbitral body. What is your opinion on it?
A second degree, so a mechanism with an arbitral appeal.
Yes, I believe so. He did not explain it well, but I believe it's the second appeal.
Well, why not? I mean, everything is possible. And it's very rarely the case in arbitral proceedings, including in commercial arbitration, because the purpose of arbitration is to go fast and to have a decision delivered rapidly. And if you have appeal mechanisms, of course, that delays the moment when you have a final outcome. But it is always possible. Of course, it will only exist if there is agreement to establish such an appeal mechanism. But that's always a possibility. I don't have any example currently in force.
I see. Well, Professor, the last is not a question, it's a comment of Yasmin Karuta said she's curious whether there are any international treaties being made about the procedures of judgment about nullity of interstate disputes. But as you said, there's not a procedural common, but yes, it's possible to have, but
no. Yeah. The only draft treaty that really, I mean, that could be considered as a draft treaty, it's not a treaty. It's a model rules, the 1958 model rules by the ILC. But they are not binding as such. You can start arbitration and you can say between us we agree that the 1958 model rules apply. And then if you agree on that, it becomes binding on the two parties that have agreed that. But there is no general treaty for providing for annulment rules.
Okay, Professor. Okay, Professor, thank you a lot to be here with us, International Law Center. And I hope you will be here in the next section. And thank you a lot and have a good day.
Thank you so much for hosting me, Tiago. Thank you again to all the participants. And I wish you all a very good day also.
Thank you.
Take care. Bye-bye. Bye-bye.
Bye.
Good morning, everyone. We should already be live. It is my pleasure to welcome you to the lecture of Professor Catarina Fernandez on behalf of the International Law Center. Before introducing the professor, I would like to shortly introduce myself. My name is Florencia Brusco. I am a lawyer from the University of Buenos Aires and a Master of Laws from the University of Groningen in the Netherlands. And I specialize in criminal law and international criminal law. Professor Catalina Fernandez is head of the Department of the Universal Human Rights System at the Ministry of Foreign Affairs of Chile, where she deals with litigation before the Inter-American Commission and the Inter-American Court of Human Rights. She has also served as consultant at the International Nuremberg Principles Academy in Germany, as legal officer at the National Preventive Mechanism Against Torture in Chile, and as judicial fellow at the International Court of Justice. She holds a Master of Laws in International Law from University of Cambridge, and she has been a lecturer in several universities in Latin America. So once again, we would like to thank you, Professor, for your availability for this online lecture. It is an honor to have you with us today. And before giving you the floor, I would like to invite the attendees to leave questions in the comments, as we will have 30 minutes for answers after the presentation. So without further ado, Professor Fernandez, please, the floor is yours.
Thank you so much, Florencia. Can you hear me well? Okay, thank you.
Professor, perfectly.
Thank you. Thank you, Florencia, for the introduction, and thank you everyone for joining us this morning. Well, depend on the place of the world you are. It's morning here in Latin America. And thanks, of course, to Cedine for inviting me to join this amazing group of lectures. And I'm honored to join such renewed colleagues from all over the world to discuss important topics of international law. I'm sorry that I cannot see you who are attending here at this meeting, but I hope we can engage more constructively at the last 30 minutes of this lecture, when you are very welcome to pose general questions on the topics of the lecture and more generally about international criminal law and enforcement, which is the topic of my lecture. Just before starting, I want to note that although I do work at the Ministry of Foreign Affairs, for obvious reasons, everything that I am saying in this presentation only represents me as an academic, and of course does not represent the Chilean government in any way. I'm here on my academic capacity. So I have a PowerPoint presentation just because for me as a lecturer and also as an attendee, it's usually easier to follow slides to avoid losing the rhythm of the conversation. If anyone is later interested in getting the slides, I will give you my email account, and feel free to contact me either directly or through the organization if you have any further questions, if you're interested in the slides, or if you want to, I don't know, have a further dialogue on this topic. So just a second, the PowerPoint is loading. I think that's ready. Okay, so just in case, my email address is over there. It's C Fernandez as my name at derecho.uchile.cl, which is the university where I'm working right now in Chile, University of Chile. So happy to stay in touch with anyone after this lecture, or if you don't get the email written then down now, feel free to ask the organizers for it. So as you were told, my lecture is going to discuss domestic enforcement of international criminal law, mostly in Latin America. This is part of an ongoing research that I'm working on and will be published in a book generally on enforcement of international law in English, probably beginning of next year, I hope. So this is a work in progress. And that means that there are some ideas that I'm just developing, and that's also another reason why I would love to hear any feedback and questions you may have at the end. And the topic is enforcement, but it's enforcement of a specific branch of international law, which is international criminal law, and analysis from the experience we have in Latin America. But to do so and to go to the, let's say, core of this lecture and of this analysis, we need to start with some issues which point up to fundamental questions of international law. Because the question of enforcement in international law is not an easy one. You probably remember the first time you studied international law, I surely do remember it. And as a lecturer, I get this question quite often from students. Well, but is international law really law? Because we're dealing with a specific, let's say, area of law that does not seem to comply with our traditional understanding of the law. Most of us, when we were in the first years of law school, started studying theory of law, and we maybe read or commented on authors such as John Austin or Hart, whose understanding of the law as an institution did not seem to adequate to what international law is. And one of the main reasons, maybe not the only one, but one of the main reasons why international law makes us raise this question is this really law? Is this just not morality or any other criteria that does not have this legal status? One of the main reasons that I'm saying for this is the issue of enforcement. Because our understanding of the law requires some measure of enforcement. And if we go back to traditional theories of what the law is, we could go back to what John Austin said about the law. He said he had what we call this command theory of law, which means that law is any order backed by a threat. So the idea of a threat is the element that we usually see international law lacks. Or as we will see, it doesn't really lack it, but has some problems in the implementation. So John Austin very famously held that international law was not law. It could not be called law because it did not have these elements that for Austin was the fundamental elements of law, which were this idea of a threat to back the order. We have the orders, but we don't have the threats. As you of course know, John Austin's theory of law is not mainstream today, among other reasons, because Herbert Hart, in his book, The Concept of Law, explained that the theory of this command theory of law, this idea that law is only order backed by threats, is not a correct understanding of what law is. And we're not even speaking about international law. Even domestic law does not comply with that understanding and that definition. So Hart will provide a more sophisticated account of what the law is. But even considering that account, international law does not seem to comply with these requirements. And one of the elements that international law lacks, even in the Hartian theory of law, is that the Hartian theory of law has primary and secondary rules, and the secondary rules includes rules of enforcement and what Hart calls enforcement officials. Well, international law, as we will see, does not have a very sophisticated centralized mechanism of enforcement. We usually explain this very simply by saying, well, there's not a police, there's not an international law police. When states do not comply with their obligations under international law, we have very limited ways of forcing them to comply. And that is, of course, different to domestic law. So Hart will not conclude that international law is not law, but he will argue that international law is a primitive kind of law, because modern law should have this special feature of a centralized mechanism of enforcement and the existence of enforcement officials. I do not want to go here on this very long debate of whether international law is law or not. This is a long discussion that could be not only one lecture, it could be a whole course. But I just want to make, let's say, the general points. And the international law scholars have addressed this issue, and they have noticed that, well, it is true that international law is not law or does not, let's say, fulfill the classical requirements of law, especially with regards to enforcement. There's no point in denying that enforcement of international law is different than enforcement of domestic law. There's no point in denying that we don't have this centralized mechanism of enforcement, or that this does not take place in the same way that it does in domestic law. But Una Hathaway, who's a professor from Yale, and Scott Shapiro have this very interesting article where they say, well, why do we argue that a system is only law if it seeks to affect behavior in the same way as modern states do it? So what they do is that they examine different systems of law, and they realize, well, not all systems of law seek to affect behavior and at the end ensure enforcement in the same way. So why do we expect international law to behave in the exact same way as modern systems? And only if we find that international law complies with that, then we will conclude that international law is law. What they point out is that critics of international law do not consider that, I mean, let's say in another way, critics of international law require for a system to be law that we have a specific organ that enjoys the monopoly over the use of force and that employs this monopoly to enforce its rules. If we find that, then it's law. If we don't find that, then it's not law. And Hathaway and Shapiro notes that, well, a regime may still be law, and that is the case of international law, and incorporate other means of enforcement. So as we will see, and we will then move to international criminal law, but generally speaking about international law does have mechanisms of enforcement. It's just that they are different to domestic mechanisms of enforcement because, among other reasons, they're not internal and centralized. As we will see, international law generally and international criminal law specifically externalize enforcement in a way. And one way in which this happens is, of course, by recurring to domestic law. So we will see that domestic law is, in a way, another means of enforcement of international law. And thus, international law will be able to use domestic law to, in a way, fill the gaps that international law is facing in this regard. So as I was saying, this lecture and my specific research, as I said, is still ongoing on enforcement of ICL, international criminal law, and the specific case of Latin America, draws from this analysis. We will understand that at the end, domestic enforcement of international law is a way in which international law relies on national courts and national mechanisms of enforcement, which do comply with this traditional view of the law, to ensure compliance with its provisions. So it would not only be that international tribunals and international officers are enforcing international law, but we will be seeing international law enforced domestically. And in that way, we will be able to, as I say, fill some of the gaps that the international system has. As I was saying, it's not that international law does not have mechanisms of enforcement. International law actually has centralized mechanisms of enforcement. You probably are aware of the immense powers of the UN Security Council. The Security Council has the power to enforce compliance of international law, even by allowing a use of force. So, as you are aware, there's a general prohibition on the use of force in international law, which has some exceptions. One of its exceptions is the authorization of the Security Council under Chapter 7 of the UN Charter. So it is possible to enforce international law, even with a centralized organism, and even with a form of enforcement that is quite similar to the forms of enforcement we know from domestic law. Let's say we could make the argument that the UN Security Council is the, let's say, police of international law. It certainly has the powers to compel compliance with international law. But of course, the Security Council has several problems and issues, one of which is that it's a political organ. And a political organ does not always have the interest of enforcing international law. It's an organ also of which whose members are allowed to exercise, whose permanent members, 5 permanent members, have the right to exercise the veto, which means that even when other states want to use the Security Council as a means of enforcement of international law, the fact that one state, one permanent member of the Security Council does not want to exercise that power is sufficient to impede the action of the Security Council. So we have a centralized mechanism of enforcement, but it has problems. It's not perfect. It has happened the Security Council has exercised its powers of enforcement, most notably in the Gulf War at the beginning of the 1990s. But it will not always be the case. International law, and then before moving to domestic law, also has its own decentralized mechanisms of enforcement. So, as you are aware, domestic law recognizes measures of self-help quite extraordinarily, because we understand that in domestic law, it's not necessary for individuals to use measures of self-help, because individuals may go to institutions, to enforcement officials, as Hart called them. So self-help is very limited in domestic law. And some of the most famous cases in domestic law will be self-defense in criminal law. And generally, in most civil law jurisdictions, the possibility of a party who is experiencing a breach of contract to also avoid complying with its own obligations under the contract. That's also a measure of self-help. If you don't comply with your obligations under our agreement, I will not comply with my obligations under the agreement. But that's basically it. Domestic law does not widely recognize self-help as a measure of enforcement, because again, self-help might be problematic, and individuals can go to the system organized mechanisms of enforcement. On the contrary, international law does recognize measures of self-help quite widely. So we will also have self-defense, which is the other exception to the prohibition of the use of force that I just mentioned. One is the authorization of the Security Council. The second is self-defense. So if a state is attacked, an armed attack against the state takes place, that state is able to exercise self-defense against the other state, right? But in addition to that, international law recognizes a wide variety of other measures of self-help. And the greatest example is countermeasures. I don't know how well you remember the regulation of countermeasures, but countermeasures basically allowed states to deny complying with one of their obligations under international law with respect to another state in response to a previous violation of that first state to another obligation. And this is much wider than what exists in domestic law. In domestic law, typically, a party that suffers a breach of contract may not comply with the obligations from that same contract. So if you offer to sell me a TV and you don't give me that TV, I cannot pay you the money, right? So my refusal to comply with my obligations will be the same obligations that the other party is also, or the obligations arising from the same contract that the other party is not complying with, right? Well, that's not the case in international law. Countermeasures allow a party to avoid compliance of a completely different obligation. So if one party is not complying with its obligations on trade, the other party may decide not to comply with its obligations on a different topic. Of course, there are limits. Countermeasures have some substantive limitations. But generally, countermeasures allow states to use these mechanisms of self-help to, let's say, enforce international law, or in a way to impel the other party to comply with its obligations, precisely because centralized mechanisms of enforcement do not always work. But let me go back to what I was saying before. This is the traditional mechanisms of enforcement of international law. The UN Security Council for centralized enforcement and decentralized enforcement by measures of self-help that states are widely allowed to take. However, the one specific measure of enforcement that I want to focus the rest of my lecture on is national mechanisms of enforcement. Because as I was saying, international law may rely on national law, on national courts, or national mechanisms of enforcement, which traditionally do comply with the understanding of regular, modern law that we were just explaining, to help comply, to help enforce their domestic rules. So in a way, the help, the cooperation, the support of national legal systems will help most or several international rules to actually operate. So in a way, we don't need to understand international law and domestic law as two different and separate systems, but quite actually, they are two systems that overlap. And there are areas, and ICL will be actually one of those areas, in which we may have the work and the mechanisms of enforcement of international law, but also domestic law will have regulation on this specific topic and will be able to contribute to this process of enforcement. Let's then move to international criminal law. We were talking generally about international law, but let's focus on international criminal law. Before examining specific enforcement of international criminal law, we need to clarify what do we actually mean with international criminal law, because this is not always a very clear concept. And if you go through the doctrine, you will see that authors use the concept of ICL sometimes in different ways. And some authors argue that the concept of ICL is sometimes a complex or problematic. It's important to be sure that we're talking about the same thing. So there are three bodies of law that may be covered under this genre of international criminal law. Some authors call ICL national criminal law applied transnationally. So in different circumstances, the domestic law of states concerning robbery, corruption, sexual violence, homicide, etc. So the, let's say, traditional domestic law of a state may be applied transnationally. In some circumstances, states exercise jurisdiction for conduct, individuals, and or property that is taking place or is located outside their territory. The most typical example is that several states exercise jurisdiction for crimes committed by their nationals abroad, which is a case of active personality basis of jurisdiction. So I'm Chilean. The Chilean law provides that some crimes committed by me outside of Chile will be covered in the jurisdiction of Chilean laws, because for whatever reason, Chile is interested in ensuring that its own nationals comply with certain rules even outside their territory. Okay, there are different circumstances in which this might take place. Some countries also exercise jurisdiction for crimes committed outside the territory, but when the victim is a national of the state. So again, I am Chilean, I go out of Chile, I suffer a specific crime. Of course, not every crime. Some crimes have these special rules. I am the victim of a crime. Well, Chile might be interested in exercising jurisdiction for that crime. So here, ICL, because some authors do call this ICL, international criminal law, is actually just national law applied outside the borders of the state. That is not what we will be discussing during this lecture. The second option is what we call treaty-based crimes. Some authors call this hybrid, transnational criminal law, or transnational crimes. I'm just using these different terms in case you read one or the other when going through the scholars. These are crimes included in a specific treaty, which impose upon states obligations typically to enact legislation concerning that crime, including that specific crime in their national legislation, and also typically require states to exercise jurisdiction over those crimes unless the state is willing to extradite that person to another state. This is what we call in Latin, because of course, as lawyers, we love using Latin for no relevant reason. Aut dedere, aut judicare is the expression in Latin, which means you either first prosecute this person in your own domestic laws, or you extradite it to another country that is willing to exercise jurisdiction over them. Treaty-based crimes, so these, again, crimes that states are obliged to include in their national legislation and to exercise jurisdiction over them unless they're willing to extradite the person to another country, is not what we will understand of international criminal law. There will be some overlap on what we will actually understand as international criminal law and treaty-based crimes, because again, some treaty-based crimes are also included in what we will call pure international criminal law. But also treaty-based crimes may cover other areas. There are treaty-based crimes and corruption. We will not be including that in our analysis. That could be another interesting analysis that someone may conduct. What we will be speaking when talking about international criminal law is what David Luban calls pure international criminal law. David Luban is actually the one that I'm following when covering this, let's say, three bodies of law that some people call international criminal law. And let's say pure international criminal law is a body of law that actually originated after World War II. It's a quite recent body of law, which created international tribunals, criminal tribunals, to punish what we usually call the most serious crimes. Some authors call it the core crimes, which are genocide, crimes against humanity, war crimes, and the crime of aggression. That is what we will understand as international criminal law. Is this body of law concerned specifically with certain most serious crimes that affect the international community as a whole, and that the whole international community has an interest on prosecuting. I was saying there will be some overlap with treaty-based crimes because, for instance, torture is a treaty-based crime. And torture, if other requirements are met, may also be a crime against humanity, or may also be a war crime. The same is the case for an enforced disappearance. Enforced disappearance is also a treaty-based crime that, again, in some circumstances, may also comply with the elements and requirements of crimes against humanity. So there might be some overlap, but what we will be actually focusing on is pure ICL. Of course, domestic laws, and we're talking here about domestic enforcement, courts deal with these three areas. Domestic courts may be applying their national law transnationally in the first hypothesis. Domestic tribunals may be prosecuting for crimes established in treaties, complying with the obligations of their treaties. But we will only focus on this third element, this third provision, which is the idea of these four core crimes. And what we'll be studying is how national courts deal with these four crimes. And as I'm saying, this third understanding of international criminal law, this pure ICL, is something quite new. It's something that only arose after World War II, when the victors of the Second World War decided to create this international military tribunal to prosecute those most responsible, in this case, for the crimes committed by Nazi Germany. And of course, this picture is from the Nuremberg trials, or the Nuremberg trial, actually, the main trial, which is the one that took place before the International Military Tribunal. And these individuals were actually prosecuted for three of these four core crimes: crimes against humanity, war crimes, and the crime of aggression, which was then called crimes against peace. Why not genocide? Well, because genocide was just starting to be discussed. Of course, there are conducts for which these individuals were tried and prosecuted that resemble our understanding of genocide, but they were then convicted for crimes against humanity because the concept of genocide was still being developed in international law. So I guess, again, genocide, crimes against humanity, war crimes, and the crime of aggression, which was previously called crimes against peace. Why should we care about domestic enforcement of this area of law? We're just saying that pure ICL is an area, let's say a specific branch of international law that originated after World War II, and that was characterized by the creation of international tribunals. So we had the International Military Tribunal in Nuremberg, but right now we have the International Criminal Court. The International Criminal Court, as you may know, based in The Hague, in the Netherlands, is a permanent international court that might prosecute individuals that commit international crimes. So we have an international means of enforcement. We have a specific court, and this specific court can do everything that, let's say, or almost everything that a normal criminal court will do. They can arrest individuals, they can investigate them subject to proceeding, convict them, and enforce the sentence. Why should we then care about domestic enforcement? Why do we actually need something else than the international system that we have established after World War II? Well, there are two main reasons, let's say. One reason is that even with the International Criminal Court, and even with this permanent institution in charge of prosecuting individuals for international crimes, the so-called impunity gap still prevails. In other words, there are crimes that the International Criminal Court cannot prosecute for different reasons. Because the jurisdiction of the International Criminal Court is not unlimited. And the jurisdiction of the International Criminal Court has as a consequence that some crimes, some individuals, some conduct may not be investigated and prosecuted and sentenced by that court. For instance, the jurisdiction of the court, the International Criminal Court, Ratione Materia, which is the substance jurisdiction of the court, will focus on these 4 core crimes: genocide, crimes against humanity, aggression, and war crimes. However, not all state parties of the ICC are obliged by the same or have accepted, let's say, the jurisdiction of the ICC with respect to the same crimes. The ICC, for instance, has 123 member states, but not all 123 member states have accepted the jurisdiction of the court with respect to the crime of aggression. The ICC also has, or the state parties to the ICC have agreed on different amendments to the Rome Statute, including new crimes, most notably war crimes. There have been several amendments to Article 8 of the Rome Statute, which include the war crimes, and not all states have accepted those amendments. So quite clearly, there are certain crimes with respect to certain countries for which the court will not be able to exercise jurisdiction. So if we want those crimes to not be, to face justice in a way, the ICC will not help us. The ICC will not have jurisdiction over those specific crimes for those specific countries. So we need domestic laws to fill that gap. Ratione persona, the International Criminal Court, may only exercise jurisdiction, and this is something that goes together with the 4th requirement, ratione loci, or the territorial jurisdiction of the court. Generally speaking, the ICC may only exercise jurisdiction for crimes committed in the territory of a state party or by individuals, by nationals of a state party. So those are the 2 elements, ratione loci, regarding the place, territory of a state party, or regarding the individual, ratione persona, which is a national of a state party. But again, if the crime is committed outside the territory of a state party, or by individuals or by individuals which are not nationals of a state party, then the court may not exercise jurisdiction. So again, it's only national. Let me give you a very simple example. A crime committed by a US national in US soil is not subject to the jurisdiction of the ICC. Or a crime committed by a Chinese national on Russian soil, because neither Russia or China or the US or India or many other countries are not members of the Rome Statute. So the court may not exercise jurisdiction over crimes committed in their territory or by nationals of that country. So again, we need domestic courts to fill that gap, that to prosecute these crimes that may not be prosecuted by this international court. And there are other practical reasons that might explain this impunity gap, even if we're dealing with crimes committed in the territory of a state party and or by a national of a state party. Even if we're dealing with the crimes that states have accepted the jurisdiction for, even, sorry, I forgot one element, which is ratione temporis. The court may only exercise jurisdiction to the future, let's say. So the ICC started its functions in 2002, and generally speaking, may only exercise jurisdiction for crimes committed after 2002. And for states that ratified the Rome Statute later, like Chile, the court may only exercise jurisdiction after the entry into force of the Rome Statute for that specific state. In the case of Chile, it was 2009. So the court may only exercise jurisdiction over crimes committed after that date, and everything that took place before is out jurisdiction of the court. So again, there are jurisdictional limitations to the exercise of the court that may require us to rely on national courts. As I was saying, in addition to this jurisdictional limitations which explain this so-called impunity gap, there are some practical limitations. Sometimes, even if the court may exercise jurisdiction because the crimes are part of the jurisdiction of the court, the person that committed the crime is a national of a state party, the crimes took place after the entry into force of the Rome Statute and took place in the territory of a state party, maybe there's no cooperation. Maybe there are limited resources. Maybe the court, for practical reasons, is not able to exercise jurisdiction. The court, the ICC, will never be able to prosecute all international crimes because it has limited capabilities to do so. So the court will generally focus only on the most responsible ones, leaders, either military or civil leaders, etc. And even when dealing with the most responsible ones, there could be a lack of cooperation. Let me give you a very easy example. There's an arrest warrant by the ICC against President Vladimir Putin for crimes committed in Ukraine. Ukraine is a state that has accepted the jurisdiction of the court. So the court theoretically may exercise jurisdiction. It's a crime committed in the territory of a party that has accepted the jurisdiction of the court, complying with the other elements of the jurisdiction. But there is no cooperation because, for obvious reasons, Russia will never hand over Vladimir Putin. And even if he travels abroad, there's a huge risk that other states may not be willing to arrest him for political reasons, and that may not allow the court to exercise jurisdiction over him. So again, there's this problem that the international mechanisms will not be sufficient to address compliance with international criminal law. And even we need to remember that this is not always problematic. The system of the International Criminal Court always assumed that states were going to exercise jurisdiction at the same time. And this is what we usually call complementarity between the ICC and national courts. The ICC never intended to exclude domestic enforcement. The ICC, the system of the ICC, always assumed that states had to exercise jurisdiction over these crimes because, again, maybe those will be the ones that can exercise jurisdiction over individuals that are not the most responsible ones, or because they're able and they're willing to exercise jurisdiction even over those who are most responsible. So the court works in a mechanisms of complementarity. It's not a competition between domestic courts and international courts. The ICC assumes, once again, that domestic courts will have something to do, will have a saying in this, and will actually exercise jurisdiction. But also there's a question of legitimacy. Again, the arguments that I was mentioning before on why she would care about domestic enforcement point to the fact of some of the gaps, some of the problems, some of the issues, legal issues, let's say, of international criminal courts and the ICC particularly. But there's also these questions of legitimacy. For some, and this is of course controversial, this may not be the case for everyone, but for some, national courts are seen as more legitimate than international courts. Sometimes local communities distrust international courts. Let's not forget that international courts usually speak a different language than the language spoken by national communities, and have a formal setting that may seem foreign to some communities. So some argue that domestic courts have this positive element that brings justice quite literally closer to the victims, and that actually might help in the process of finding justice for these serious and very grave international crimes. So let's now ask the question on how can we evaluate enforcement of international criminal law in Latin America, which is the specific area of my research. Enforcement requires some ways in which national courts or national systems impel compliance with international law, affect legal process coercively, pursuit, arrest, detain, trial, and sentence an individual. That is our traditional understanding of enforcement, and that is what we will be focusing. So let's say a straightforward way to evaluate domestic enforcement of international criminal law is to examine national criminal proceedings where a national tribunal has to deal with the four core crimes. They're pursuing, arresting, detaining, trialing, convicting, and sentencing an individual for these four core crimes. This is a straightforward way to see how domestic court enforce international criminal law. But there will be some questions, and of course that is why this research is worth analyzing. It is not as straightforward as I was just implying, because will national courts be actually invoking international law? Let's imagine a national court dealing with genocide or dealing with crimes against humanity. Will this national court be invoking international law? Well, not necessarily. In some cases, they might. In some cases, national courts may actually rely on the sources of international law, on treaties, on the case law of international criminal tribunals, etc. And that would be a very easy way of seeing, oh, yes, this domestic tribunal is enforcing international law. But again, that will not always be the case. Sometimes states may conduct these proceedings without actually referring or relying on international rules, but relying on their own legislation. Several Latin American countries, for instance, have domestic legislation which implements the core crimes. Again, I'm most familiar with the situation of Chile, of course. Chile has a law implementing the crimes. Well, actually, the three crimes. It did not include yet the crime of aggression. So if a national tribunal in Chile is prosecuting for, let's say, crimes against humanity, it does not require to rely on international law. It's quite easy just to rely on their own domestic legislation. However, I argue, and this is of course maybe accepted or not, I argue that this could also be understood as an indirect application and enforcement of international criminal law. Because even if national tribunals are only invoking national legislation, again, this will sometimes be the case. Sometimes tribunals invoke both international law and their national legislation. Again, those will be the easy cases. But even if states only invoke their own national legislation with respect to the core crimes, or even with respect to other elements, the substance, the origin, let's say, of this national legislation implementing the core crimes will be international law. These countries, let me say this in very simple terms, countries did not invent crimes against humanity, genocide, war crimes, and the crime of aggression out of the blue. It was not a moment of creativity by national legislators. Most countries, and we can usually see this from the travaux préparatoires of the law itself, let's say, will use international law as the source of their own national legislation, even if at the end they make some amendments or changes. Chile implemented a law on core crime, on the 3 specific core crimes, after it, or at the same time actually, that it ratified the Rome Statute, precisely to make possible this element of complementarity that I was just mentioning. So even if a national court is only relying on national legislation, again, the origin of those domestic laws that are being applied by domestic courts is international law. So this is, I argue, another example of domestic enforcement of international law. What happens in Latin America? Let me use the last 15 minutes to focus specifically on Latin America and what we can see from our history. Latin America has a wide history in the prosecution of international crimes. Kai Ambos, a German scholar, argues that Latin America is, together with Europe, the region where the most prosecutions of international crimes have taken place during the last few years. This is mostly because Latin America has had to deal with its own past. So, as we all know, Latin America lived a history of dictatorships, general authoritarian governments, in which several grave violations of international law were committed. And several of those violations do amount to, quite typically, crimes against humanity, but also in some cases genocide and or war crimes. So there, in different countries of Latin America, of course, Chile is the one, again, that I'm most familiar with, but also in Argentina, in Uruguay, in Colombia, in Guatemala, in Peru, amongst other countries, there have been several prosecutions for these crimes committed during these dictatorships or authoritarian regimes that, for obvious reasons, may not be dealt with by the International Criminal Court, among other reasons, because these crimes were committed prior to the entry into force of the Rome Statute. That, however, was not always the case. So we have now a wide case, a wide array of examples of international criminal law being applied in Latin America. But that was not always the case. This was done in, there was a significant role, let's say, played by the Inter-American Court of Human Rights, because it was several decisions of the Inter-American Court of Human Rights that ordered Latin American countries to declare void amnesty laws, to ignore the statutes of limitations, and to actually reopen when the investigations were closed, or start, when no investigation had taken place, investigations for the crimes committed during these years. And here's which a very important institution developed by the Inter-American Court of Human Rights takes place, which is called the conventionality control. As has been argued by the Inter-American Court of Human Rights, national tribunals may not, for instance, use or invoke amnesty laws insofar as those amnesty laws, which at the beginning banned, impeded enforcing or prosecuting these individuals, because the Inter-American Court has said these amnesty laws are contrary to the convention, the American Convention on Human Rights itself. And the national tribunals, for instance, have to exercise this conventionality control. So if they want to apply the amnesty law, they need to examine whether that amnesty law is compatible with the convention. That is why it's called conventionality control. If it's not compatible with the convention, then they must not apply that specific law. And that will, of course, have as a consequences that the prosecutions may continue. Quite interestingly, this had happened in Latin America in different countries, and allowing for the reopening and starting of investigations for these serious crimes, even with the amnesty laws, legally speaking, still being valid. So several countries have not actually repealed their amnesty laws. It's just that they're not using it in complying with this criteria of the Inter-American Court of Human Rights of this conventionality control, and understanding that as amnesty laws are incompatible with the convention, they may not be used, they may not be invoked, and investigations then must continue. So, as I was saying, this has allowed us, the quote from Cayambos was explaining, Latin America being the region where the most prosecutions of international crimes have taken place. However, not all national legislations in Latin America had a specific domestic laws on international crimes. Although most states of Latin America are members of the Rome Statute, and most members, or I don't know if most, but at least several states have adopted implementing legislation on international crimes, this legislation may not be used for dealing with its past. So Latin American countries could not use their specific legislation on crimes against humanity, or the specific legislation on genocide or on war crimes, due to the simple fact that those legislations were enacted after the crimes. And one of the basic requirements of criminal law is that no criminal law may be applied to crimes committed prior to the enactment of the law. So national legislations and jurisdictions in Latin America had quite a problem. They had to apply international criminal law, but they did not have the domestic legislation appropriate to conduct those prosecutions and to actually enforce international criminal law domestically. So they had to use different mechanisms for doing so. And again, the help of the Inter-American Court of Human Rights was quite significant, because there are some differences, and for obvious reasons, I won't be able to go into much detail of each specific country here today. But different countries, as again mentioned, dealt with this in different ways. So in Argentina, for instance, we had this Juntas trial, which was probably there's actually a movie that was released a couple of months ago. If you haven't seen it, it's quite recommended. This trial of the military man most responsible for the crimes, that was this one big case of enforcement of international criminal law, and this idea that individuals may be prosecuted for these grave crimes. But later on, Argentina enacted amnesty laws, and amnesty laws prevented the possibility of continuing these proceedings and stopped all investigations for a while. Amnesty laws were later on annulled, and that allowed the subsequent proceedings. And one of the, I'd say, most interesting cases to examine now in Latin America is how Argentina is currently dealing with what is sometimes called the ESMA mega case or mega trial, which is a trial for different crimes, coming from torture to assassination, sexual violence, amongst enforced disappearance, amongst many others, that all took place, or that all started, let's say, from ESMA, which was a center for torture and extermination, which was in Buenos Aires. So Argentina had some mixed experiences with prosecuting in these international crimes. Chile is also, in a way, similar to Argentina. Chile also had an amnesty law. And also, even when amnesty laws were not considered, because it was established that amnesty laws were contrary to the obligations of the American Convention on Human Rights, these crimes were still subject to statutes of limitations. These statutes of limitations did not allow tribunals to prosecute crimes that had taken place 20 or 30 years before that, because, of course, the statute of limitations had already expired. the case law had to evolve and understand that particularly enforced disappearance, which was one of the crimes committed by the Chilean dictatorship, was actually a permanent crime. And as such, it could not be subject to statute of limitations, because statute of limitations assume the existence of a unique and limited in time crime. And if the crime is permanent, then the statute of limitations cannot even start and thus cannot expire. Interestingly, in Chile, as one of the issues that I was mentioning, Chile does have legislation implementing the 4 core crimes, or the 3 core crimes, but Chilean courts could not use that law for these crimes because the law was adopted in 2009, and these crimes took place between 1973 and 1990. So of course we could not apply that law retroactively. What did national tribunals in Chile do? And this is also the case in other jurisdictions in Latin America, which I think is why this analysis is so interesting. They did what we call in Spanish, and I'm not sure what's the proper translation in English, so I'm sorry about that, doble subsunción, which means that tribunals were using 2 systems or 2 frameworks of law at the same time. So as domestic courts could not rely upon the specific law on crimes against humanity, what domestic tribunals did was applying the, let's say, ordinary crimes, regular crimes, rape, homicide, kidnapping, etc. So that is applying domestic law. But at the same time, national courts were applying international law to argue that that homicide, that sexual violence, that rape, that kidnapping, etc., was committed as a crime against humanity because it was committed in a widespread or systematic attack against the civilian population. And in that, national tribunals in Chile have relied upon international law. So again, they use both international and domestic law combined to conclude that this is not just a regular homicide, a regular ordinary case of sexual violence, but it's actually sexual violence as a crime against humanity. Peru, we see a trend. Peru also had an amnesty law. However, the Inter-American Court of Human Rights in the Barrios Altos decision argued that that amnesty law could not be considered, and that Fujimori, which was the then leader of Peru when these crimes were committed, had to be convicted. There was a trial of Fujimori. Fujimori was also convicted for crimes against humanity in not exactly the same, but I guess it's similar reasoning than the one conducted by Chilean courts on this idea that this is a crime that, although we may invoke national law, it has the source of international law that gives it its international character. So Fujimori was tried, was convicted, but was then pardoned. And then the Inter-American Court of Human Rights said that that pardon needed to be annulled, and that Fujimori need to actually face justice. And I want to end, almost end. I have just 3 more minutes left, and then we will open the floor for questions. On Colombia, Colombia is quite an interesting case because it's one of the few ones, and I guess Venezuela could also be that in the future, but there has not been significant prosecutions in Venezuela yet. But Colombia is dealing with its past, but it's dealing with this past at the same time that also is facing the possibility of a proceeding by the International Criminal Court. So Colombia has, let's say, a more sophisticated system on prosecution of these crimes. As you may be aware, there was a peace process, and amongst many other institutions, that peace process created what we call the Special Jurisdiction for Peace, or Jurisdicción Especial para la Paz in Spanish, which is able to prosecute individuals for, in the case of Colombia, a big amount of crimes are actually war crimes because are crimes committed within an armed conflict, but also crimes against humanity. Interestingly, however, the national courts are aware that some of these crimes may also be heard or may also be subject to jurisdiction of the International Criminal Court. And this is quite different from the other examples that I was giving. In Chile, in Argentina, in Peru, there's no chance for even though these three countries are members of the Rome Statute of the International Criminal Court, these countries may not, the ICC may not exercise jurisdiction for these crimes committed in the past, because these countries accept the jurisdiction of the court only with respect to future crimes, of course. Colombia, however, is different because several of the crimes continued to take place after the ratification of the Rome Statute. So that means this is the only case of national prosecutions in Latin America that is, in a way, competing with the national enforcement, competing with international enforcement. It's not actually competition, because as I was mentioning, the system of the International Criminal Court is one of complementarity, which means that the International Criminal Court actually encourages national jurisdictions to investigate these crimes. And this was, for instance, reflected in the fact that the International Criminal Court had a preliminary examination on Colombia, which was finished, because the International Criminal Court had the opinion that up to that date, the investigations and prosecutions taking place in Colombia were sufficient, and it was not necessary then for the International Criminal Court to intervene. So as we see, there's different mechanisms. Some cases, some countries have their own international crimes legislation, as in the case of Colombia. Some countries have had to come up with both international and domestic law combined to allow for the prosecution of these crimes to be understood as international crimes and not simply domestic crimes. And one final thing to mention is that in some cases, but this is very still limited in Latin America, but it could grow in the future, so there's no point in ignoring it, is that in some cases, and this has taken place mostly in Argentina, there have been attempts to exercise jurisdiction for international crimes, national jurisdiction for international crimes committed outside that country's territory. And this is under what we usually call universal jurisdiction. So Argentina, for instance, there have been attempts to exercise jurisdiction for international crimes committed by the Franco dictatorship in Spain, the Rohingya genocide in Myanmar, or the death of Jamal Khashoggi, to which Saudi Arabia is being, or actually bin Salman from Saudi Arabia is alleged to be responsible. This is quite new. This is not something that has a big development, but as is the case in Europe, for instance, Europe has lots of cases of domestic courts exercising universal jurisdiction, and this is also a case of national enforcement of international criminal law. In Latin America, this has not yet been successful, and it's quite recent. So it's something worth examining to see whether it moves to other countries other than Argentina. Chile had a weird attempt to invoke universal jurisdiction in a human rights case, which is not exactly what universal jurisdiction is supposed to be for. Universal jurisdiction is the exercise of criminal jurisdiction. Oh, I'm sorry. I think I lost my connection for a moment. Can you hear me now again?
Yes, perfectly.
Yeah, sorry, I was just finishing. This was my last slide. Just to finish, wait, there it is again. Just to finish, my last point is that this whole development of international criminal law in Latin America has been subject to some criticism. Some have argued that Latin American courts have expanded international criminal law. The traditional criticism of Latin America as a case of, as examples of judicial activism is also quite common in doctrine. So this is not a development that is without its criticism, but I think it's still worth and interesting to examine, even if sometimes Latin American courts do not apply international criminal law correctly, even if sometimes they expand international criminal law to cover conducts that are actually not covered in international law, even if some of these cases or examples may be presented as cases of judicial activism. I think it's worth examining how Latin America deals with these issues, because we don't see this analysis quite often in doctrinal analysis. We usually focus on Europe. We usually focus on international courts. And we don't see how, let's say, other countries deal with domestic enforcement of international law and international criminal law specifically. So again, this is a work in progress. I would be happy to hear any comments and questions that you may have, either specifically on the developments of Latin America or more generally on these questions of enforcement and international law. So I finish here and I give you back the floor, Florencia, and all of our attendees for any questions and comments that they might have. I'm just going to stop sharing. Thank you.
Thank you very much, Professor, for your presentation and for sharing the insights of your research. Especially the last part, I think it's very noble. And currently, less than a month ago, I've seen that the George Clooney Foundation has presented a claim against Venezuela in Argentina. And actually, the prosecutor has opened the investigation for potential liability of Venezuela. So it's something that is still developing. So it's really interesting to hear your findings in this sense. So far, I have not seen any question on the chat. So I invite again everyone who is watching the presentation to leave a comment. We have a first comment from Marla Carelli. Marla says, thank you so much, Professor, for bringing such an important topic to us. Could you please provide more precise information about the mechanisms that can be used to impel compliance? It continues in a second comment, which says, particularly in the case of Brazil, considering its history of non-compliance with such sentences.
Thank you. Well, I'm not an expert on Brazil, so I guess I can just make some general comments that might then be used by those who are experts to complement. But I think that's why the role of the Inter-American Court of Human Rights has been so important, because several countries in Latin America did not have a very good, let's say, track of complying with international law, and particularly in the case of my specific research, complying with their obligations to prosecute, prosecute these very serious crimes. Several countries, as Argentina, Chile, Peru, Uruguay also did not want to actually initiate these proceedings for different reasons. Political reasons were, of course, a big part of it. Some countries felt that going through their path had a risk of opening the doors to controversial questions nationally. But the Inter-American Court had a very significant role there. And this was not something that the state originally accepted. We have to remember that cases brought before the Inter-American Court are cases that have been initiated by individuals. So these were individuals that, for instance, wanted to initiate criminal proceedings against those responsible for the crimes committed against them or against their loved ones. National tribunals declare those cases closed for applying the amnesties or the statutes of limitations. And then these individuals and their lawyers went to the Inter-American system, first, as we know, to the Inter-American Commission, arguing that the fact that these tribunals, national tribunals, did not continue or start this investigation for these very serious crimes was contrary to the obligations of that state under the American Convention. This was a long fight. Several victims were in the Inter-American system for 10, 15 years, claiming that investigation and prosecution of these very serious crimes was an obligation of states. It was not something just to be optional for states to decide whether it was politically convenient or not. And they managed, after much struggle, to get a positive decision from the Inter-American Court of Human Rights, which orders states to reopen those investigations. So I think here, what I want to say, again, I don't know the specifics about Brazil. Brazil is not part of my research, mostly because of idiomatic reasons. I don't speak Portuguese, so I would not be able to go through the sources direct. I mean, I guess I can read a little bit of Portuguese, but not enough for legal research. But I think we need to highlight the specific roles that have been played by victims. And this is also another reason why I think this is important to examine from Latin America. Victims have been the leading role here, claiming for justice again and again and again, until either by order of the Inter-American Court of Human Rights, in some cases by the political pressure, domestic courts finally decided to reopen these investigations and prosecute international crimes. So of course, my homage to victims goes here, and also to understand that this is contested and this is not something sometimes states are willing to do openly. This needs to be controversial. Sorry, it does not need to be controversial, but it's usually controversial. And it's only through fights and strategic litigation and using the Inter-American system of human rights that we have been able to be where we are right now. It's not perfect, of course. Even in countries that have dealt with prosecutions as Argentina, Chile, Peru, there are many gaps, there are many problems, but at least it's a way forward that I hope other Latin American countries will also be able to follow. I hope that's helpful as a general answer. Again, I'm not expert on the specific case of Brazil. Thank you.
Thank you, Professor. And also thank you, Marla, for sending your question. You could send a question as well. The question says, one of the problems you mentioned is that judges apply ICL wrongly. How to change this? How to promote education of international law to judges? Would it also not help with the cohesion of ICL?
Yes, this is a very important topic. And this is actually a reaction to a comment I received from European scholars. The first time that I presented this paper, as I said, this is part of a book. So we had a symposium a month ago with other scholars. And some European scholars said, well, that is not ICL. Latin American courts are not applying ICL because they're mixing up ICL with their own national legislation. The case of Chile is quite telling, by the way. They're applying international law wrongly, so we cannot call that enforcement of international law. And I think there are 2 points, and then I will actually go to the specific question. I think it's what we understand to be ICL. So if judges apply criminal law wrongly, is that not a case of applying criminal law? We can, of course, make the criticism, and I think the criticism is worth doing it. I think we should expect our national tribunals to be more precise in invoking and applying international law, and there's different things that may be done in that way. Of course, teaching and activities such as these are quite relevant in making this area of law, which was not developed in Latin America. Let's not forget that international criminal law was developed for Europe by Europeans and Americans as in US Americans. So this is not something that sometimes Latin American jurisdictions are familiar with, and that is reasonable. We need to continue teaching about this. Students more and more learn about international criminal law in their law schools, but this was not the case 10 or 20 or 30 years ago. So there's a lot to be done. But I think even if we're able to constructively identify problems in the reasoning. And I think there are many examples of that. For instance, Chilean laws have applied the Geneva Conventions quite wrongly. I think it's still an exercise worth doing, and it's interesting to see how, even with their sometimes limited knowledge of international law, even with the limited resources national tribunals had, they wanted to comply with international law. Maybe they did it poorly, maybe they made mistakes, but there was, and this is quite clear from some decisions in which they specifically invoke international law. National tribunals wanted to comply and enforce international law. So I think that is worth examining in more detail. And again, in any area of law, we can see judges messing up. If we're studying constitutional law or civil law, we can find decisions of the Supreme Court of countries which we will see this is incorrect. That's the whole point of being a lawyer. I guess in several points, there's debate and argument on whether that is a correct understanding of the law. So even national courts dealing with national legislation are subject to criticism and debate. So this, of course, will also be the case for a foreign system and institutions such as international criminal law. But again, there's much room to improvement. I think lawyers more and more in Latin America are more familiar with these topics. The experiences of Colombia and Venezuela now, with all the proceedings before the International Criminal Court, have actually opened the door for different individuals to see that this is a new area that maybe they were not so familiar with. So there's a lot of improvement, but I think this is also an exercise really worth examining and not just ignoring, as with all due respect, some European scholars do. Oh, that's just not ICL. I think it's an interesting example of how domestic judges see ICL.
Thank you very much. There are two more comments in the chat. Before moving to them, Marla, who asked the first questions, thank you so much. And if possible, she says, I would like to read your research. Do you have any means of contact or website that I can access?
Yes, I was mentioning my email address was at the beginning of the presentation. It's C. Fernandez, as my last name, at Derecho, DERECHO, which means law in Spanish, .uchile, University of Chile, uchile.cl. If you miss it, feel free to contact the organizers, and I'm happy for them to give you my email address. This research is not yet published. As I was mentioning, it should be published next year, but I'm happy to share it if someone is interested and to stay in touch with any further questions.
Nora asks, could you talk a little bit more about international law and politics in Latin America? Would it be possible to create a mechanism of enforcement free from political interference?
Well, that's a tricky question, because I guess international law is always dealing with politics. I don't think that there's a way of having a free from politics international law. And criminal law, international criminal law, should not be so imbued by politics, but especially, as I was mentioning, as the cases of enforcement of international criminal law in Latin America are mostly cases of countries dealing with its own past, politics are imbued in the whole conversation. Of course, that should not be the case. Judicial decisions should be blind and neutral to all political visions and parties, but I guess sometimes that's too naive. The only thing that we can aspire is to have independent tribunals, ideally clear legislation that will reduce the spaces of arbitrariness. The fundamental role played by victims is also, let's say, a relevant influence in ensuring that this process is as free from politics as possible. But whenever we're dealing with power, it's impossible to ignore politics. And most of these cases are countries dealing with its own past of abuse of power and authoritarian governments, etc. I think this might change when and if Latin America moves from dealing with its own past to dealing with the future. And then cases such as the one of Argentina that I was mentioning, the few cases of universal jurisdiction in Argentina, and even the case Florencia was mentioning that was just started, those are cases that might, in a way, be a little, not completely, but somehow excluded from the political analysis because they do not have the burden of history behind that. I think that's, in a simple way, the problem of Latin America. Latin America is dealing with the burden of its own history, and that's never easy. It was not easy for Germany when Germany was and continues to be dealing with its own past. There are actually still prosecutions for crimes committed in Nazi Germany against individuals that are now 100 years old. And this is still political in Germany. So I think, I don't want to say that we should absolutely resign to this fact. We should, of course, fight to find mechanisms of justice that are as independent, impartial as possible. And I think that can be done. I think Latin America, with all its issues, has a history of strong institutions that need to be reinforced. And I think generally, there are sadly some exceptions, but several Latin American countries have independent courts that provide sufficient guarantees for an independent proceeding. But we cannot ignore that politics will be talking on the side. I think that's impossible to avoid. And I think we just need to accept it, to create mechanisms to avoid the influence of politics in the judicial proceedings. But politics will still be there.
Moving on to another question from Carolini. Carolini says, dear professor, do you consider that including the international criminal law provisions into domestic law is enough for better enforcement of it? And if I may, I would like to ask a second question to Carolini's, because what you were explaining, for example, more into the beginning of the lecture about the implementing gaps, I was thinking if you would see feasible in the future to have an intermediate sort of place for international criminal law within Latin America, in between domestic courts and the international criminal courts. I'm thinking about, for example, the Latin American criminal court, if you would say that it's something that is possible.
Yes, let me go to the first question and then the second one. Implementing legislation, I think, is important. I think it's worth pursuing. Several Latin American countries have it, not all of them, and there's, of course, always room for improvement. Several legislations need to be updated. As was mentioned, there are new international crimes. I don't think there might be one, but most, at least, national legislations in Latin America have not yet included the crime of aggression. And I think with the Russia invasion to Ukraine, this reminds us that it is a crime that is still happening, and it's always important to have that provision. Because again, if we have the provisions in national law, it will be easier to prosecute these crimes in the future. Having domestic legislation enacting international crimes will also help national tribunals, because again, the problem of national courts is that they did not have a national legislation that they could rely upon. So they had to use this mix of national and international law. And that, of course, created some confusion and problems. I think it's normal. So if we have a domestic legislation that clearly explains a crime against humanity requires a specific context, which is a widespread or systematic attack against a civilian, blah, 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 blah. And then we have specific conduct that needs to be committed within that context. Well, it will be then easier for crimes to apply these rules correctly. So I think it's relevant. It's, of course, not sufficient. We need to go to use this along with teaching and both lawyers and judges learning about these new institutions. And I think there's a lot to be done, but there are some very encouraging developments. As to the second question, this has not been quite a significant debate in Latin America, but it has in Africa. Some of you may remember that during the first decade, I guess, of the International Criminal Court, there was quite some controversy because the International Criminal Court was only prosecuting Africans. So there was this claim, quite significant, that the court was basically racist that this was another form of colonialism, that we were using international courts to prosecute Africa. So European judges and European prosecutors, well, the prosecutor was not European, but it was white. It was a white Argentinian. So white individuals prosecuted black individuals. This was awful. It was really, really controversial to see this. Again, some argue that this was a new form of colonialism and that it was unacceptable for a court to focus exclusively on Africans when we could very clearly see that crimes were committed elsewhere in the world and this was not being considered serious enough. So in Africa, there was quite some controversy. There were several countries who threatened to leave the ICC. Only one did at the end. But even South Africa, which is usually one of the lead examples of prosecuting crimes locally, South Africa was threatening to leave the ICC because of these claims of bias and racism in the courts. And one of that at the end did not happen. South Africa did not leave the court. But I think Burundi was the only country that actually withdrew from the statute. But one of the proposals then was, let's create a regional court for prosecuting these crimes committed in Africa. I don't know if that's necessarily a solution, but I do see the benefits. And again, this brings me back to the question of why sometimes individuals prefer national courts over international courts. Well, regional courts sometimes are closer to national courts. Regional courts usually speak the language of the local communities, or at least a language that it sounds familiar. They have the cultural practices of the local communities. In Latin America, all countries deal with justice in a quite similar way. Of course, there are some differences, but if you go to a proceeding in Argentina, in Peru, in Colombia, even in Brazil, they won't be so completely different to each other. So local communities may feel more comfortable in a regional court, let's imagine, that follows those practices by individuals that look like them. Let's not ignore that element of legitimacy, of course. The fact that an individual is being prosecuted and judged by individuals that look like him or her, it's not irrelevant. And this is the point of legitimacy. So I guess in a way, some may argue that regional courts are the way forward. And this is, by the way in which we have decided to work with human rights. We don't have a universal court of human rights. We have regional courts of human rights. And one of the reasons for that is that individuals and countries were willing to have a court that was more close to their national jurisdictions. And as anyone who has studied both the American court and the European court can say, they are quite different. They are quite different. And one of the reasons why they are quite different is because one is in Latin America and one is in Europe. And the way in which we deal with law is different in these jurisdictions. So I think it's worth examining. It's not my favorite option. I do support the idea of an international criminal court along with very strong national jurisdictions, but I think it's a plausible theory. And as I say, in Africa, it was very popular for a very long period of time.
Thank you very much. I am waiting to see if someone else has a question. We are almost finished. It's 29. Yes, Professor, there are no more questions. So being that we are almost finished with time, I would like to take the opportunity to thank you again to have been part of this course, to have shared your insights. I will be also looking forward to the publication of your research. Indeed, it seems really interesting and really novel. Like, there are topics that they are being discussed now, they are moving forward. And I think that my biggest take from your presentation is when you said that Latin America has to start looking forward. We have revisited our past and it's really necessary, but we have to start also going forward. So with this universalism, for example, I think there is a way there to find new solutions to all these issues that we have been discussing today. So thank you again. Thank you everyone who has joined. And well, I will be looking forward to your research.
Thank you so much, Florencia. Thank you to Sedin for the invitation. And thank you everyone for your interesting comments and questions. Again, happy to stay in touch with anyone if interested. And best of luck with the continuation of this amazing program. Thank you so much and have a great rest of the day, everyone. Bye-bye.
Thank you again. Have a great day.
So, good afternoon, attendees of the 19th International Law Winter Program of the Brazilian International Law Center. My name is Tatiana Skefi, and on behalf of the International Law Center, I welcome you to the lecture of the most esteemed Professor Xu. Professor Xu is a judge of the International Court of Justice, professor of the School of Law of Wuhan University, vice president and member of the Council of the Chinese Society of International Law, member of the Institut de Droit International since 2009, president of the Asian Society of International Law from 2009 to 2011, member of the Curatorium of the Hague Academy of International Law from 2010 to 2016. She is a honoris causa in law by the University of Macau, receiving it in 2013. The topic of her lecture today will be the value of fundamental principles of international law. Once again, thank you very much, Judge Xu, for the availability for this online lecture. It is a great honor to have you with us today. Professor Xu, the floor is yours.
Thank you so much, Professor Tatiana. It's indeed a great honor and a privilege for me to attend this conference held by Brazilian International Law Center. Now I understand how famous this center is. Two distinguished ICJ judges came from this university. At the outset, I wish to pay my special tribute to my beloved colleague, the late Judge Antonio Canzado Trinidadi. His passing is a great loss for the court, I'm sure for the Brazilian international law community. His legacy and great contributions to the development of international law will always be remembered. Judge Canzado and I were not just colleagues in the court. We're very close friends. We share a lot of common interests, and at the same time, we appreciated each other's different perspectives on issues of international law. In many aspects, Judge Canzado's approach to international law reflected the paramount interests of the Latin American continent in international law. That is, protection of human rights and the promotion of social development for the benefits of the people. I was very much inspired by his scholarship, as well as his passion for international law. As a practitioner, I tend to look at the discipline from both the individual angles and the state's perspective. In today's lecture, I wish to highlight one important aspect of international law, the value of basic norms of international law in the contemporary world order. Professor, I will speak about 20 to 30 minutes and then open the floor for discussion. I really like to engage with the audience and have a direct conversation on issues of our common interest. Contemporary world order was established after World War II. It was based on the fundamental principles and the rules of international law as enshrined in Article 2 of the UN Charter. These basic principles include the principles 1, sovereign equality of states. Second, faithful fulfillment of international obligations. 3, peaceful settlement of international disputes. 4, non-use or threat of use of force against the territorial integrity or political independence of states. And the 5th, non-intervention in internal affairs. In the post-World War II period, 2 additional principles were further developed and became part of the core principles of the world order. Namely, first, respect for human rights and fundamental freedoms. And second, the right to self-determination. In the early days of the United Nations, two major developments in international relations deeply affected the world order. One is the onset of the Cold War between the Western Bloc and Eastern Bloc, led respectively by the United States and the Soviet Union. The geopolitical rivalry and the tension between the two superpowers constantly gave rise to concerns of international peace and security, and seriously affected international cooperation in other fields. Another major development is the decolonization movement that spread from Asia and Africa to the rest of the world. In the past, those colonial countries had no legal status in international law. They were not even recognized as the subject of international law, and they had no right to take part in international affairs and no right to conclude treaties. On the 14th December 1960, the General Assembly adopted the Declaration on the granting of independence to colonial countries and peoples, also known as Resolution 1514, which solemnly declared that colonialism is a denial of fundamental human rights, is contrary to the Charter of the United Nations, and is an impediment to promotion of the world peace and cooperation. All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. It was necessary to bring to a speedy and unconditional end colonialism in all its forms and manifestations. In 2019, in the advisory opinion on legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965, the International Court of Justice recalled the decolonization movement in the 1960s, stating that Resolution 1514 represents a defining moment in the consolidation of state practice on decolonization and clarifies the content and the scope of the right to self-determination. Indeed, in the 1960s, within a short span of time, 46 colonial countries exercised their right to self-determination and achieved independence. By 1970, the membership of the United Nations had, from its initial 51 states, expanded to 127 states. Today, there are 193 member states in the United Nations. The impact of a decolonization movement on the world order is far-reaching. It not only changed the political landscape of the world, but also broadened the voices of the developing countries in the development of international law. As soon as these nation states entered the world stage, they identified themselves with the principles of the Charter as the basic norms of their international relations and put them into practice in their external relations. In 1954, China, India, and Burma, now Myanmar, initiated the 5 principles of peaceful coexistence, namely, first, mutual respect for sovereignty and territorial integrity. Second, mutual non-aggression. 3, non-interference in each other's internal affairs. 4, equality and mutual benefit. And 5, peaceful coexistence. The leaders of the 3 states stated that these principles will govern their relations as well as relations with other countries. The 5 principles, in essence, reflect the principles of the UN Charter. As the Chinese Premier Zhou Enlai pointed out, we respect the right of the people of all countries in choosing their lifestyle and state systems without external interference. Well, we request other states to do likewise to us. We are of the view that if these principles are observed by all, countries of different social systems could live in peace. In the following year, 29 Asian and African countries gathered in Bandung, Indonesia, and discussed issues of their common interest, namely peace, economic development, and decolonization. This landmark even gave rise to the non-aligned movement and the subsequent establishment of a group of 77, G77, in the United Nations, which strengthened the unity and the solidarity of the developing countries and enable them to defend collectively their common interests in the multilateral negotiation process of the United Nations. For the first time, the developing countries collectively made their voices heard in promoting a fairer world order. With these new states on the world stage, the foundation of international legal order was expanded, turning from Eurocentrism to a genuinely universal order. The primary task for international development after World War II was to codify and develop international rules and principles. For a long time, international law studies were mainly carried out by scholarly bodies. Multilateral treaties concluded among states were very limited, both in number and in content. In 1947, the General Assembly established the International Law Commission, ILC, to codify international law and promote progressive development of international law, and drafting treaty articles for adoption by states. To date, the Commission has studied over 80 topics on various subject matters of public international law and produced nearly 50 sets of articles or study reports, 23 of which were subsequently adopted into international conventions. Apart from LC's work, another major approach for international law development is the multilateral negotiation process under the auspices of international organizations, particularly the United Nations. Through diplomatic conferences, states negotiated and concluded international treaties to regulate activities that affected the common interests of the international community. For example, the Law of the Sea conferences. The third UN conference on the Law of the Sea, which lasted for 9 years, from 1973 to 1982, with 160 states participating, negotiated and concluded the UN Convention on the Law of the Sea, UNCLOS. The convention laid down a comprehensive legal framework for the world's oceans and seas, governing all uses of the oceans and their resources. Some new regimes under the convention substantially changed the legal order at sea. The importance of the multilateral negotiation process on climate change hardly need explanation. At the Second World Conference on Environment and Development, the real conference in 1992, state parties adopted the UN Framework Convention on Climate Change, which sets out the basic legal framework and the principles for international climate change cooperation. To continue the negotiation process, conference of parties have been held annually since 1995, and the process is still going on. This is the longest and most comprehensive multilateral negotiation process affecting various aspects of our life. During the post-Cold War era, improved international relations provided a propitious environment for international cooperation and promotion of international law. The following 2 decades, however, witness a perplexing period. On the one hand, eruption of ethnic and internal armed conflicts, terrorism, and other forms of non-traditional security threats pose new challenges to world peace and security. In the armed conflicts in the Balkan region, Middle East, and African countries, massive serious violations of human rights and breaches of international humanitarian law called for global action. On the other hand, economic globalization and regional economic integration immensely boosted world trade and economic development worldwide. With the rise of the new economies, millions of people have been alleviated from poverty. Alongside states' cooperation, non-state actors became increasingly active in the field of international law. In the course of this complex and dynamic development, a few features can be observed in international law development. The first feature is there's a clear shift from state sovereignty to state responsibility in the international law discourse. While the basic norms and the principles of international law underscore the rights and obligations of states, the emphasis now is being shifted to state responsibility. Coupled with this trend is the rapid proliferation of international courts and tribunals. Various international judicial organs and arbitral tribunals have been set up in many fields. The second feature is that human rights protection becomes the central theme in international law. This phenomenon permeates into every aspect of a UN agenda. The impact of this development is also reflected in the work of the court. In recent years, the court has dealt with quite a number of cases concerning human rights treaties, including Convention Against Torture, Convention on the Elimination of Racial Discrimination, CERD, and the Convention on Genocide. Among the 20 cases currently pending, 6 cases concern interpretation and application of human rights treaties. The third feature is that non-state players have entered the world stage. States and intergovernmental organizations are no longer the exclusive players in international lawmaking. Non-state actors have increasing influence on the formation of international rules and norms. This is particularly true in the fields of human rights, world trade, and environment. The last feature is the fragmentation of international law. International law has branched out with a growing number of specialized treaty regimes, such as human rights law, trade law, environmental law, the law of the sea, air and space law, etc. This phenomenon is being described as a fragmentation of international law. Today, we can hardly find an encyclopedia-type scholar for public international law, as we used to know. One may specialize in one or some of the fields, but not all of them. This also shows that international law has substantially developed. International rules and standards have penetrated into every aspect of our life. Indeed, it is on that basis we are talking about global governance or rule of law. Fragmentation of international law has its negative impact on international law. Different interpretation and application may be adopted by different special treaty regimes and by different courts and tribunals. Moreover, fragmented approach of special regimes may prejudice the intrinsic structure of international law, weakening the relevance of the basic principles and norms that have overarching effect in the interpretation and application of international law. On a more fundamental basis, one must understand that the current political, economic, and legal order has always been primarily Western dominant. International law, as the basis of international legal order, has been oriented by the preferences of the Western world and mainly reflects Western liberal values. This is particularly true during the 3 decades since the end of the Cold War. Notwithstanding those features, we can't fail but to see that there are increasing communal interests shared by all states, such as environmental protection, human rights promotion and protection, and the fight against international crimes. But to realize those goals, states are the crucial actors at both national and international levels. In recent years, the tides of international relations have turned dramatically into a different direction. Instead of globalization and multilateralism, unilateral acts are disrupting international cooperation, weakening the existing international multilateral systems, particularly the United Nations. Today, international law has acquired special significance for states, particularly the developing countries, to effectively participate in international affairs and protect their legitimate interests. As is said by a scholar, the discipline has now become an extraordinarily powerful language in which to frame problems, suggest fault and responsibility, promote solutions and remedies. International law rules matter and must be taken seriously. It's not simply a distinctive style of argumentation, but has serious consequences for how ordinary people live. If democracy in international relations mean anything, all states, particularly developing countries, must take an active part in the development of international law and provide their views and solutions to global issues. For nearly 80 years since the founding of the United Nations, the basic norms of international law have stood the test of time. However, international relations have changed, they remain relevant and vital for states and the peoples. In searching for solutions to global issues, I'm confident that international law will continue to play a positive role. Professor, I think I shall stop here and open the floor for discussion. Many thanks for your kind attention.
Thank you, Judge Shu. It was a very enlightening lecture on the evolution of international law and the characteristics of international law today. We do have some questions. The first one relates even to one of the aspects that you were mentioning regarding the third feature of current international law, regarding the plurality of actors that are now making international law. One of the students here, he asks, should we be concerned about the ICJ exercising its jurisdiction over cases brought by applicant states on behalf of a non-state actor, such as an international organization, in the future? In the sense, what impact does the formal decision made by the majority in the Gambia versus Myanmar judgment may have on the equality of parties principle? So this is the first question that we have on this part regarding the plurality of actors. Regarding now another aspect that you mentioned on fragmentation of international law, and also regarding the plurality of courts that we now have. You mentioned that there are many courts and tribunals that have now been proliferating, but then we have, for instance, many advisory opinions being asked for a number of courts, for instance, on climate change that you mentioned. The ICJ is now facing one advisory opinion. ITLOS is facing an advisory opinion. The Inter-American Court is facing an advisory opinion. Should we be worried about maybe different positions of the courts, maybe relating to the fragmentation of international law, or shouldn't we be worried about that because of the first character that you mentioned, or the second feature you mentioned, the humanization of international law? Do you think that will guide all of these courts, and we shouldn't be worried, as the IOC posed in one of its works regarding the fragmentation of international law? So these are two first questions. So we can start with those, and there are other questions here, but let's start with those.
Thank you. They are very, very good questions. I don't see the audience. I already can sense the level of their international law knowledge. I'm very impressed by this question. I'm so happy. The first question shows the audience have indeed followed ICJ's work and read carefully our opinions and reasoning, both in the court's judgment and reasoning in the individual opinions of judges. In principle, on the whole, I would say it's a positive development that non-state actors, NGOs, and international organizations have become more active in international law making, and to add the voice of the people from the grassroots, and not just states, international intergovernmental organizations that took part in the process. That said, there is one element I want to emphasize, draw attention of international scholars. When we praise, hail the positive development in this field, we must also be very careful to pay attention to the role of NGOs, what NGOs who are so active in the process, and the impact of what organizations that really can make their voices heard. You know, I'm from developing country. I always pay attention to the real impact of the contributions from Global South. And when we talk about NGOs, we must bear in mind that generally speaking, NGOs from Global South are not as strong as those from Global North. Oftentimes, their capacity and their influence are not so powerful and limited by their available resources. So there is an imbalance there, is the first point. Second one, when we talk about NGOs, we also have to be careful to whom they are accountable and what kind of responsibility, accountability they could bear while they participate in the process. So when we see this positive development, we must look at it with a critical eye. Now, the second layer of this question is about the courts, ICJ practice in particular. Yes, indeed, you must have read my opinion. I wrote to the appended to the judgment in the Gambia versus Myanmar case. I was indeed worried. This type of quasi-axio popularis, public interest litigation at the world stage, particularly in the court, where it will lead when the statute and the rules of the court offer no guidance. How can we maintain the equality of the parties, but also the due process for all concerned? So I hope that you will follow up on this and watch over and watch out this kind of a trend. I would, if I can say this is trend, because strictly speaking, we can't find, such legal basis in the statute and rules of the court. The second question regarding fragmentation of international law, and indeed, you gave a very good example that different courts have received not identical but similar questions, whether we should worry about different, if not conflicting interpretation on rules of law, the applicable law. But I have to say at the moment, maybe it's a bit premature for us simply to worry. Because, for instance, the legal question presented to ITLOS on climate change is limited by the mandate of the tribunal, is limited to the climate change on the maritime environment and related to the law of the sea. Well, the question presented to the ICJ is much broader in general. So maybe the two institutions in their approach to the question could come up with advisory opinion that will address different aspects. Regarding to Latin America court, there's the third layer, how the court will give advisory opinion. What kind of advisory opinion it will give also very much depends on the court itself. And generally speaking, the court is aware of what's going on outside. So hopefully we'll make, concerted efforts to address this global issue with a common goal that all states and all the parties concerned will be mobilized to combat this common threat to the globe as well as to mankind. So this is how I can answer it, but I cannot go to the details because the advisor opinion request is still pending. The case is still pending before us.
Perfect, no problem, Judge Shu. We do have other questions. One of them is regarding the development of international law. In your opinion, what does it still need, where the improvements are, and what does there's need to be developed even in the world order in order to achieve a better improvement, I would say. I guess the student here is trying to ask you what is your opinion regarding the development of the international order and where can we focus on improvements of the international legal order. Another question that we have here regards erga omnes obligations. The question is, Judge Shu, do you think that the concept of erga omnes obligations has been stretched beyond its true meaning? If so, what are the consequences of this? This is another question. So maybe we should stick into this two and then we move on to the other question that is already there.
Thank you again. It's a very, very good question. It's very contemporaneous to the current development. The first question I gather the scholar wished to know, in my view, where we can do to improve international legal order and develop international. I must say, as I indicated in my speech, though briefly, in the past 3 decades, since the end of the Cold War, the tension of international development very much in certain areas that basically reflect Western liberalism. Well, you may notice within UN system, World Bank, development issues are diminishing. You see? And during the Cold War period, through UN system, there always official development aid, development issues always on the agenda. But in the past few decades, after Washington Consensus, the experiment or the practice in the field has proved not so desirable, not so successful. But not much effort were picked up to strengthen international cooperation for economic and social development. It's still very much left to the market. And even though with economic globalization, we can still see developing countries are still struggling with this tendency. So I think with international law development, we of course have common issues like climate change, but climate change itself is not a simply environmental issue. is deeply related with development. So this is the area developing countries can contribute their ideas on the basic legal rules and norms that would govern international relations, promote common interests, common development for all. So this is one area. Second one, we face some increasing issues derived from advancement of technology. For instance, cyber crimes, you see, and also regulations with the technology, e-commerce, and new forms of crimes that cross international borders. So there you need a lot of international cooperation, but at the moment, you could feel there's no political will, particularly on part of some states. And for what can be improved, very much depends on political will of states. I have to say, very unfortunate, we are still struggling to build up a positive dialogue. Second question regarding aga omnes obligations. First of all, in international law, the concept of aga omnes obligations or jus cogens have been accepted by states, but states still disagree, still hold divergent views on what constitutes the obligation aga omnes, what constitutes a jus cogens. So that's the problem. This is one thing. Secondly, whether this idea has been stretched a bit far, I feel that in some cases, yes. In some cases, particularly if you recall the past cases, jurisprudence of the court made it very clear aga omnes obligations are substantive rules. They do not affect standing or procedure of the court. And now we see it seems there is a mixture. It's something quite different from the Gambian versus Mir case. So we'll see its impact. Apparently, there are some opinions are very much for expanding the concept, and particularly for international litigations. But whether that would be healthy to promote international law and facilitative of international relations, I'm not so sure. Whether we could have actio popularis, public action, public litigation, it's fine. But if all states agree we should have it, but we should have rules first, make it clear what kind of legal procedure that should be followed, who is in the position to represent international community as a whole. You cannot simply, on the current basis of the rules, just like magic, create new rules without legal basis. And then you may have unexpected consequences. So again, this is how far I can say about pending cases. I'm obliged not to discuss them in detail, but I'm so happy as international lawyers, you have already paid attention to this important issue because it concerns all of us.
Indeed. Well, let's move on to the next question. Here is a question regarding unilateral sanctions. It's written, Judge Xu, in light of the recent decisions of the ICJ regarding economic sanctions, do you see the widespread implementation of unilateral sanctions as a result of this fragmentation of international law? In the sense that even though there are several bilateral and some multilateral treaties which allow this implementation of economic sanctions, there is a lack of specific limits of this practice, especially concerning its impacts when it targets developing countries. Do you agree with this view? If so, how do you see the future of international law in this matter of implementation of unilateral sanctions as a result of fragmentation of international law?
To be honest, unilateral sanctions, if in abstract, is very difficult to discuss them in terms of international law. Unilateral sanctions, as we see, sometimes based on national law, and sometimes based on regional arrangements, sometimes simply by group of states. On what basis you challenge the legality or validity of those unilateral sanctions very much depends where you stand. Of course, within the United Nations, in the Sixth Committee, the Legal Committee, for many years, there was a special commission discussing the consequences of sanctions on other states, particularly developing countries. Indeed, the consequences for developing countries in many cases are harsh and unfair. But so far, we haven't seen any concrete results derived from the deliberations by the Sixth Committee, and for the simple reason that is very much of political consideration. To say fragmentation of international, when I talk about fragmentation, I didn't mean this type of fragmentation. In this particular context, I would say it's a fragmented approach to international legal order. Pick up what you like and give up what you don't like. So this being criticized by many countries, but it's very hard to make any legal judgment on a general basis, but certainly I'm fully aware of the inquiry from this question to challenge the practice of unilateral sanctions. Indeed, today there are too many unilateral sanctions that destabilize international relations. So, but I think this question a little bit beyond my judicial function, but I welcome the thinking underlining the question, because after all, such unilateral acts or unilateral sanctions challenge the very foundation of international law. If we talk about the rule of law, there must be a legal basis for this kind of sanctions, a legal basis recognized by all states. So-called rules-based law, the rules must be international law. Otherwise, we don't have order. So this is my appreciation of the question. Thank you.
Perfect. And just to another question, my question then now, because this question relating economic sanctions and your answer regarding that it is disproportionate to countries, especially those from the global south. During your lecture, you also mentioned that the decolonization movement is also important, dating back from the 1960s, and how we have now this movement trying to still Europeize international law to make it not Eurocentric, to make it truly international. And the Chagos Archipelago advisory opinion was a turning point on that, because in that advisory opinion, we had a firm view of the court saying decolonization must happen and countries cannot be still colonies even after more than 40 years that we have now the self-determination principle. And I have been following the discussions of Prof. Lin and the Hague Academy regarding post-colonial international law. And I would say that this is another issue that we must face in the current years and the years to come, because we still see this imbalance between countries from the global north and countries from the global south, even in the making of law, because sometimes it is difficult for countries from the global south to propose law in the international arena. So I would like to know if you could comment a little bit more on that, if it would be possible, on your opinion. This is something truly my interest. And I will also make the last question we have here from our audience. It says, I would like to discuss a little bit more about fragmentation and what are the consequences for the future and for the legal system itself. So I would say that this is something also very interesting if we come to think on colonial and post-colonial international law, right? Because if we come to think on fragmentation and how fragmentation can also be a consequence of this imbalance that we have from countries from both sides. So these are two questions. If you could comment a little bit more on those, please.
Okay, I thank the audience for raising these two additional questions. I am fully aware of the fact that economic sanctions always had their hardest hit at the global south, because their economic structure is more vulnerable to such sanctions. And oftentimes, instead of hitting the target, the sanctions hit the developing countries. Of course, the global north must pay enough attention to this aspect if they really wish to use sanctions to maintain the right to use sanctions in certain cases. But back to the question of decolonization movement, I think this is historical development. And in the 2019 advisory opinion, I appended the individual opinion. I particularly discussed two aspects of the legal questions presented to the court. One is whether this is a bilateral dispute between the parties concerned, the UK and Mauritius. My conclusion, I thought the court in the advisory opinion should have addressed this issue because the parties and the states during the legal proceedings intensely debated on the issue. My opinion is very clear, made very clear. I don't think this is a bilateral issue between UK and Mauritius. It was an issue left from the decolonization process of Mauritius. And UK at the time intentionally create new colony for the purpose that the archipelago, the island could be used for military base purpose. So that's absolutely clear from the evidence. The second point I made was why, after 40 years, after Mauritius already got independent and became a full-fledged sovereign state, why the issue still came back to the United Nations. Okay, so if not a bilateral dispute, it should come to the court, but you still have to address this important issue. That is the vestiges of colonial system that still fall within the purview of United Nations. Even if Mauritius is now full-fledged sovereign state, for issues of this kind, the General Assembly, United Nations still have the responsibility to look into the matter. So, and also because decolonization is a long process. It did not finish moment when those colonies became sovereign states. International community, international law should continue to watch over the colonial impact, colonial influence, colonial vestiges that still influence international relations. You know, this is the task of a young generation of international lawyers. You must remember that history always interconnected. A lot of issues we face today still have their historical roots in the past. If we simply forget the past and assume something starting from scratch, from square one, we are mistaken. We can never see through the real issue behind. For instance, now Global South face serious challenges for their economic and social development. Why so? Why so? Because their economic structure, to varying degrees, still very much affected by their colonial past. Single economic structure, resource-dependent economy. So they need to develop and they need to have their real autonomy or real self-determination to decide where to go. But a lot of Global South countries have no such capacity. very unfortunate after so many years of independence, their economic development is still stepping, on the same ground. So this is a big challenge for us. I hope that we could have more discussions on the issue, but I have to move on to the second question regarding fragmentation. First of all, I like to point it out, I forgot to mention, fragmentation of international law is not issued now, it was not raised now. It was issue already being studied by LC, International Law Commission, many years ago, and LC produced a report, try to hold together the systematic structure of international law, and within that structure to consider the issue of fragmentation. So the audience, if you have interest, you may read that report. I think it's quite a good one. But I have to add a few personal observations. First of all, we have to say fragmentation of international law perhaps is unavoidable, because nowadays international relations have become such where many, the contacts between states, contact between peoples are so massive, so interrelated that international law have to cover as many fields as possible so as to ensure a smooth, orderly international legal order or international relationship. And so it's a natural development. We have different regimes, different international organizations, all under one legal order. So this is a natural development. We don't have to feel scared about it. But second aspect, on the other hand, we also have to pay attention to the fact when you have so many special regimes, so many international courts and tribunals that deliver their judgment by their own and without taking care of the overarching legal rules and principles, you could have very fragmented practice of international, have a conflicting practice of international, and gradually that will weaken the legal strength of the system. And I noticed, for example, in the field of foreign investment, there are so many arbitral tribunals, and oftentimes their legal pronouncements are not consistent, and they are ad hoc without instance of appeal to review those cases. Certainly you would have very fragmented decisions, and that may affect the legal development of international law. Of course, first foremost, affect the legal interests of the parties, and above all, whether you could promote international justice. So this is a key issue, and people, international legal community in general, is fully aware of it. But what we should do, and again, whether Global South can play a role, because Global South generally are the receiving countries of investment, and whether receiving countries can have a say in the process, that's a question mark. And that's why now with new economies, I hope like BRICS, like a new development bank, AIIB, Asian Infrastructure Development Bank, that the Global South voices will be strengthened, and international lawyers from the South should contribute their ideas as what to do. So this is a really very important but challenging task for all of us.
Perfect, Chu. We do have a couple of minutes left, and just a final question came in. If we could address it, do you think that we have time?
No problem. Go ahead. Okay. I need your hands. If you think we still have a few minutes left, certainly I would like to use them.
Okay.
And I really appreciate, I wish I could see the audience, but I really appreciate their participation. The questions are excellent.
Thank you, Jechu. We have now 30 students watching live our lecture, your lecture. So here we have the question. Jechu, what test do you believe the court should apply to determine if a certain case or certain claims fall or do not fall on the scope of a treaty's compromissory clause for the purpose of its jurisdiction, ratione materi, before entering the merits?
Say it again. I don't think I understand the question.
Sure. What test do you believe the ICJ should apply to determine if a certain case or if certain claims fall or not on the scope of a treaty's compromissory clause for the purpose of its jurisdiction, for the jurisdiction of the court, ratione materi, before entering the merits? I believe...
Okay, I got it.
Okay.
Well, I want to tell the audience, actually, this is our routine work. In the routine work of the court, when a state file application, a case entered the docket of the court, the respondent state has the right to raise preliminary objections to the jurisdiction of the court and admissibility of the application. And even if the parties, the respondent, does not raise objections, the court itself, we call it probo motu, the court itself still has to first examine whether it has jurisdiction in the case. If the case is based on a compromissory clause, based the jurisdiction court on the compromissory clause, the court will interpret the compromissory clause and decide whether it has jurisdiction. Once the respondent state raise preliminary objections to the jurisdiction of the court, the main case will be suspended, will not consider the merits of the case whatsoever. Only when the court decides it has jurisdiction, then the case can move on to the merits phase. And of course, when you say we have to examine the jurisdiction ratione materia, the result could always be two possibilities. Either we say we have jurisdiction, or we say the court does not have jurisdiction. When the court decided it does not have jurisdiction, the case will be dismissed. I think I understand the question to imply another layer of issue, that is if the applicant shoehorn a case into a convention, whether the court will hold the case, whether the court will decide it has jurisdiction. I fully understand. We are aware of it. And it very much depends, And this is a more complicated aspect of the issue. But I'm so happy you are thinking deep about matter, not only look at the issue superficially. Thank you.
All right, thank you, Judge Xu. And another question came in asking about the process of the writing, mostly putting together the views of the judges, of the final document of the judgment of the court. How is it done? How is it difficult to come up with a singular view? Because some of the cases we do have unanimous decisions, or sometimes we have 13 votes to 2 or 14 votes to 1, but is it hard to put together the views of the judges on the final document? How is the process of writing? I think the student here wants to know the background of the court. If you could speak a little bit more on that.
I'm not surprised by the curiosity. It's a really legitimate question and inquiry how court performs its judicial functions. As you know, when a case is submitted to the court, usually we have two kinds of proceedings. One is written proceeding, the other is oral proceeding. And if the case is complicated, normally we would have 2 rounds of written pleadings. The applicant submit a memorial, the respondent submit a counter memorial. That's the first round. And then the second round, the applicant submit a reply and the respondent submit rejoinder. So that's the first stage, written pleadings. Then when case is ready, we go to oral hearings, usually also 2 rounds. And after that, the court will retrieve to the second stage, that is deliberations. Well, first, each judge is required to prepare a note. It's like make a judgment of his own or her own, writing on all the key issues of the case, give its or her own opinion. And when all the notes are collected, then we'll have a deliberation. And there we'll see where the majority stand on each issue. And this is what you talk about, unanimity. And of course, we'll have deliberations. After written note and deliberations, each judge will give its views on each issue, and the judges will exchange views very thoroughly. And then we'll elect drafting committee members. And the president usually, if in the majority, will be the ex-official member of the drafting committee, guiding the drafting committee's work. So when they produce the draft judgment, we call it avant-projet, the preliminary draft of the judgment will make written amendments. And then we'll have 2 rounds. First reading of the judgment, consider paragraph by paragraph, line by line. And then we'll have a second reading and then vote on the operative paragraph by paragraph. And then the judges have the right to pen their individual opinions, usually in 3 kinds of form. One is you may append a declaration, make a point of law, or make an opinion. or you can you pen dissenting opinion if you vote no, and you can pen the separate opinion if you agree with the conclusion but disagree with the reasoning, or so you can give your own reasoning to the decision. So this is a long process. People often say, oh, ICJ always drags its feet and takes such a long time to arrive at a decision. But actually, most time spent are by the parties when they prepare written pleadings. When we finish all oral proceedings, the time left for the judges to work on the case usually very short. Think about this. We have to work in 2 working languages, English and French. Everything in one language must be translated in the other language. The translation work is enormous. It's enormous. We have a very professional team on linguistic, in the linguistic department, and also very effective but small team on legal affairs. So, so after the long process, if we still cannot achieve unanimous decision, we have to admit the case is complicated. Means members do not think their positions is compromisable. They would maintain their individual opinions. So it's always good to have a unanimous decision, because that means the judgment is more persuasive and more authoritative. But if a court is deeply divided, it will weaken the effect of the judgment, of course. And also very much depends on the individual opinion of the members. Sometimes the individual opinions can be very strong, and the reasoning can be very persuasive. But I have to say, this very much practice, very much reflective of a common law practice. In civil law, we don't have this kind of separate opinions attached to the judgment, or have the names of judgments recording their votes. We don't have this, but in common law system, it's widely practiced. But as far as I can see it, the advantage of this practice is when you have the judgment itself with the reasoning, because the court is obliged under statute to provide reasoning of its decision. And if you have individual opinions, either separate or dissenting opinion, that will enrich they give a better understanding, enrich the reasoning of the court, and give a better understanding of the decision, where the court is divided, where the court is unanimous. That means either in law or in fact, most members of the court agree, share the same view. But if deeply divided on point of law, then you can see maybe there's no unanimous position among states as well. The issue is still controversial. So this is my understanding of the court practice. But I have to say, having worked in the court for over 13 years, I really feel, I can see the strength, both the strength and the weakness in the working method. And there are a lot of wisdoms left by the founding fathers in designing the legal judicial system and the structure.
Thank you so much, Jichu, for this inside view of the court. Thank you so much for the lecture and for patiently listening and replying to all the questions that were made. Certainly, it was an enlightening discussion that all the students here really enjoyed. I really enjoyed. And I thank you so very much for taking the time to be with us here at the International Law Center in our 19th edition of this winter course. With this being said, and with all the thanks that we give to you for being here, I shall now end this panel by saying to the students that we resume tomorrow with the lectures scheduled for the day. I'm not sure if you have any final words, but I will pass on to you if you have any. Otherwise, I will call upon here João or even Caroline to end there for the lecture. Did you?
It's my great pleasure to be here. I really enjoyed the questions and the discussion and looking forward to another opportunity. I wish you all the best and a great conference. Thank you. The floor is back.